All right, I think I've got all the equipment in place. Again, good afternoon, everyone. Welcome to 2023. We've got a plea and arraignment calendar and a few probation, revocation, and inquiry matters. Who is helping us from the sheriff's office? Is there a particular order in which we need to go with folks in the Zoom booths?
Hey, Judge, this is Ms. Livingston. I'm assisting you all today. And no, there's no special order other than I do have a couple of inmates sharing booths on 1 North. So if possible, I do have an order. If possible, can we do 1 North first, which is position number 6 on the probation revocation calendar? And position number 1 on the plea and arraignment calendar, just so they don't have to be doubled up in the booth.
Yes, ma'am. So we will do 6 from the second calendar, indictment from 2005, and position 1. Happy to do it that way. Do we have public defenders? I think I saw Ms. Primovic. Good morning. Good afternoon,
I'm here, Your Honor, and I actually have both of those cases. So.
Okay, Ms. Feely is here. There's Ms. Wood. Great. So we've got everyone we need. We've got all sorts of prosecutors rattling around in here. I'm happy to see Mr. Jordan decided to come back this year. The couple weeks in December weren't too much.
No, I'm back for more.
Did you have a good break?
I did. How about yourself, Your Honor?
I did. Thank you. All right. So let me then get one last thing going here. That's not good. Ms. Nelson, could you reach out to IT and have someone come to 8D, please?
I will.
Thank you. I'm trying to get the website to work that unmutes the. Oh boy. We booth 1? We are booth 1. Okay. No, that's not it. There we go. I've got booth 4 listed for 1 North. I thought we were, are we booth 4, Ms. Livingston, or booth 1? I've got a mix here.
You're assigned to booth number 1, but booth number 4 was available. So we're using both of them because you have several inmates that's in the same housing location.
Okay.
Is booth number 4 not working for you?
No, I didn't. I just was activating I thought we were booth 1. So I'm going to try. Let's see. There's booth 4. Thank you, everyone, for your patience. Let's try that. Oh, that worked. Hey, there's booth 4, and it's got 2 people in it. Let's make it big. There we are. All right. So I should have in booth 4. Is it Mr. Alexander and
Yes, sir.
You're Mr. Alexander, and then we've got. Are you Mr. Hall?
No, I'm Evans. Evans.
Okay. Ms. Nelson.
That's number 8 on the P&A calendar, Judge.
Oh, okay. I was told position 6 on the other. So Chaz Evans. All right. You're supposed to be in 4 South, but we'll work with both of these. Let's start with Mr. Alexander. We've got him right here. Mr. Alexander, I'm Judge McBurney, and your case is on here for plea and arraignment. It sounds like you've got at least one other indicted case and an unindicted case. Ms. Feely, are you handling all of Mr. Alexander's business?
Yes, Your Honor. I've spoken with Mr. Alexander at the jail. Our plan is I went ahead and waived arraignment on this one. He does have the SC case that we hope to resolve together sometime later this month. And then Mr. Jordan let me know that the CP case hopefully will get declined so we can just handle those 2 cases together.
Okay. The case ending in 175 is in non-complex. Is it also a shoplifting case, or what kind of case is it?
It is.
Okay. And then just at this point, Mr. Alexander's been deemed a repeat offender, and that's why we got the case ending in 196?
That's correct, but I think we can work it out.
Okay. And then, Mr. Jordan, your intention, you're not committing to it, but your intention would be to not present whatever the magic term is these days, the CP matter. And Mr. Alexander would be resolving 196, our case, and 175, which would come to us from non-complex.
That is correct, Your Honor. And the non-complex matter, there is a standing transfer order that was filled out, I believe, December 22nd. So that should be making its way to us very shortly.
Okay. Mr. Alexander, did you follow all that? Did anything I say prompt any questions on your part?
Yes, I got a question on, I see one, it's case summary 22 SC 182429. And I see a judicial hold right here. I'm not understanding that. So I see, obviously I thought I see 3 shop. Well, I thought I had 3 shoplifting. So now I'm saying that I got 4. I want to get an understanding on that.
Okay. Well, give me 1 second, and I'm gonna need you to repeat that number, but don't do it yet, please.
Yes, sir.
All right. What was that number you just gave?
It was 22 SC 182429. The last 3 digits is 429. It says, and
Yep, I'm looking at it. I'm looking at it. So you do have I guess it would be a 4th case.
Yeah.
That's also a non-complex. You're on judicial hold because someone couldn't find you, I guess. But we're going to want to make sure that you and Ms. Feely and Mr. Jordan, the prosecutor, are looking at all of these. So Ms. Feely and Mr. Jordan, if you would add to your list of Mr. Alexander's business, 22 SC 182429, that was put on judicial hold in August of last year by, it's pulling up, Judge Borski. So we want to wrap that one into it as well.
Yes, Your Honor.
All right, Mr. Alexander, thank you for flagging that case. Do you have any other questions?
Let me see. There was okay. So to my understanding, is everything in a complex courtroom or non-complex?
It's going to all be in complex now because this most recent case, the one assigned to me, is going to serve as a magnet. It's going to pull everything else in.
All right. So now I got my full understanding now. Okay. So I'm just gonna have. So Ms. Feely is going to be my permanent public defender for this case?
Yeah, I don't know about the word permanent, but she will be your lawyer to handle all these cases.
All these cases. All right, say no more. All right, now I'm good now.
All right, so she's going to be working on your behalf. She'll work with Mr. Jordan, and then we'll get you probably over here in person in court, but it may be virtual when your lawyer, having talked with you, has worked things out with the prosecutor. And assuming that's going to be a plea, then I get back in the mix. And if I decide to accept your plea to all these cases, then you will have taken care of your business. Okay.
Okay. One last question. Do you know how long this next court date is going to take?
So let's ask Ms. Feely. What it sounds like would be next is Ms. Feely letting my case manager know that you're ready to resolve your cases. She needs to learn a little bit more about this case you just told us about to make sure it's in your best interest to resolve everything. So she's going to do that, and then she'll get back with you. But my guess is we get you over here in the next few weeks. So it's not months, but weeks. But I don't want to promise you that because it may be Ms. Feely looks at it and says, "Oh, Mr. Alexander, you've got more exposure than I thought." And then you're going to want to talk with her. But as soon as Ms. Feely says, "We've worked it out," we're going to want to get you over here because we can resolve 4 cases.
Okay, thank you. Oh, yeah. Excuse me. I got 4 felony and 1 misdemeanor, right? Because I got that, drug object, possession of drug object. Is that on there as well?
I don't handle the misdemeanors. So you got 4 felony cases with me.
Okay, so, all right. So there's no misdemeanors. All right, because it's a drug object, and I was just trying to get to a program just by that,
Okay. Well, it may be you get to a program anyway. You don't have to have a drug offense to get into a program. So you keep talking with Ms. Feely, and we will see you soon, okay?
I'll do that. All
All
right.
right. Thank you, sir. You're free to go.
All right.
So what we're going to do next, just because we got the volume on it. Hi there. IT is here. Great. Can I come on back? Oh, great. Hey, Happy New Year. The normal piece of software that I use to mute the booths, it says like the authentication has expired. I'm wondering if it's because it's the new year. You got new glasses. Happy New Year to those. Okay, you want to come around and look? I'll just show you. So I'm just using the old Zoom. So I have a workaround. I'm just using the Zoom controller, but this is what I'm talking about. So I'll click on this. Oh, now that you're here, it's going to work.
Well, that happens sometimes.
Okay, but this was the and so I quit. I got back in. I quit, and it kept giving me that. But now it works.
That means that
Okay.
that
hearing.
yes.
Okay.
You need to call us. I'll call the jail.
And then they go punch some buttons. Okay, that's all this language means is that as the jail's in, there's a hiccup. Okay, all right. Thank you.
Which one is this?
Well, it was booth 1 in 1 Northeast. 1 North. But let me try. Let me mute this again. This was the other one I tried. Well, that was booth 4. So if I go back there, this doesn't even have booth 4.
Yes, they just added this one. I didn't even know they added this one. So
Okay, yeah. So you'll need to add a booth 4 in the future.
Yes,
so what wasn't working was 1 North booth 1, but you just saw it worked. So well, but I did it manually. I'll do it manually. Don't worry about that. That worked. Okay. Thank you for coming in, and Happy New Year again. Mr. Evans. So we're going to switch things up a little bit, Ms. Feely. I don't know who represents Mr. Evans.
Good afternoon, Judge.
Hey, Ms. Wood, how are you?
I'm good. Happy New Year.
Happy New Year to you. And we're going to.
Oh, sorry.
We're going to get Mr. Shapiro up here as well, because I think he's handling this for the state. Mr. Evans, I'm Judge McBurney. Sorry you had to share that space for a little bit. Ms. Wood is your lawyer. You are charged with cruelty to children. in the first degree and the third degree. And today is your plea and arraignment day. So I'm going to ask Ms. Wood to tell me a little bit about what the plan is for your case. Ms. Wood?
Thank you, Judge. May I have a breakout session after the call of the calendar? I also want to speak to Mr. Shapiro to see if there's a possibility of resolving this one today.
Okay. You want to speak with Mr. Evans right now, or?
Whatever's best for the court, Judge. I do have a couple of other people as well, so I can wait, or if it's easier now, I can as well.
Why don't you speak with him now, and we'll just make sure because Ms. Livingston said this was the only one that we had to take in a particular order, I'll just skip over your folks while you're talking to Mr. Evans, okay?
Perfect. Thank you, Judge.
Let me see if I can pull this off. So Mr. Evans, I'm about to, if I do this correctly, you and Ms. Wood are going to move to a private space virtually. So you're speaking with her in private. Whatever you tell her, the prosecutor cannot hear, I cannot hear. Now, some dude outside your door could hear it, but it's just you and your lawyer speaking privately, okay?
Okay.
All right, we're going to give this a try.
I got one too.
Say what?
To a judge and thank you.
All right. Bingo. Whew. So let's just go in order of the calendar unless, is anyone in here who needed things to go? And was that your only case?
No, well, Judge, I have another one that I believe we're taking up at 4, which is just Mr. Walker, but I was good.
Yes,
Sorry,
because we have 2 interpreters who are helping Mr. Walker.
Yes, but if I can step out and just make a couple of calls, I think.
Yep.
Thank you.
Great.
Thank you, Judge.
Excellent. Then let's just go back to our plea and arraignment calendar. We'll go in order. Next up is Mr. Adams, but I don't see. Ms. Nelson, did you get the helpful list from Ms. Livingston that says who is where? Because it's not lining up with what's on the calendar.
Well, I sent you that information, but I can look again. Hold on.
No, if you send it to me, I'll go look for you. Send it to me when? Oh, there it is. Excellent. I've got it.
Okay.
Thank you.
Mm-hmm.
I'm good. Oh, but now 1 North booth 1 is full with different people. So let's go there first and we'll figure out who that is. Hey, 1 North booth 1. Who do we have in there?
Hilton Hall and Freddie Neesmith.
Got it. Let's see if we can do either of those. Ms. Feely, do you represent this? One of them is position 4 on the plea and arraignment calendar. Is that your case, Ms. Feely?
That is not my case, but I do have Mr. Hall, who's number 6 on the other calendar.
Let's do that then. At least then we can reduce the overcrowding in there. Mr. Neesmith, we're not skipping you. Your lawyer is just in a breakout room right now. And when she comes back, we can work through your situation. But let's do Mr. Hall. How you doing, Mr. Hall?
I'm doing all right. How you doing, sir?
I'm all right. Boy, your case, I don't know what I was doing. I certainly wasn't a judge when your case got indicted. It's from 2005.
The probation supposed to close that out.
Yeah, well, I don't know what's going on, but let's hear from Ms. Feely. That's the lawyer who's helping you out with this. Ms. Feely, what's happening with Mr. Hall?
Yes, Your Honor. So we are not exactly completely sure, Mr. Jordan and I, but in the meantime, I sent over a proposed order lifting the bench warrant so that he doesn't have to remain in jail while the state decides. I think this case needs to be administratively closed or something, but in any event, we would appreciate the court considering that order. He's been in jail 28 days.
Okay. I'm just looking at the docket now. It looks like in 2009, and you're Hilton Hall, is that right?
Yes, sir.
Okay, in 2009, Judge Downs signed a bench warrant for you in connection with this case. I don't know what was going on. She seems to think you missed court, and it sounds like that caught up with you. You must have encountered law enforcement in some way about a month ago, and this bench warrant that was, 14 years old almost, bit you in the behind.
Yeah, because I got that grant together in 2014.
Oh, I see what.
And like I got that closed on the probation officer closed it, but I ended up violating my probation for Fayette County and being supervised for Fulton County, and I believe that where the paperwork got messed up at.
Yeah, you were in drug court and you got terminated from drug court.
Yes, sir.
Okay, and that's part of what happened here. So you think your probation's done?
It was done, and she had closed it out, but Fayette did when it closed up for it, so that's the only reason.
Ms. Tucson, do you have any info on whether Mr. Hall's sentence is still active?
Good afternoon.
Hi there.
I see on here that he is in custody and that there is a case in the system that he's serving time for that is from Fayette County. And it shows active until July of this year. His Fulton County case was closed out January 31st of 2018.
And when you say his Fulton County case, I'm seeing he actually has a second case as well, but the 05 SC case, that was closed out in 2018?
No, the case that was closed out in 2018 is 07 SC 62046.
Okay, I see that. I'm looking at an order of admission into drug court that Judge Downs signed a long time ago, and it's got that 07 case, but it also has the case that's on our calendar, the 05 SC 24666. What does that case say in your system?
I actually don't have that case in my dockets for probation. The only other one is 04 SC 12823, and then the Fayette County case.
They got closed out, both of them.
Yeah, that 04 case, is that also closed out?
Yes, sir.
Okay, so the 05 case, you're saying that Mr. Hall just wasn't on probation?
It's not showing on our dockets here.
Okay.
Judge, I might be able to give a little bit of light. I
Okay.
think what happened was he was terminated from drug court, and once Judge Downs terminated him, then they put a warrant out because he didn't complete the program.
Yeah.
So that's what this warrant is for.
Okay, that's what I thought, and that was the bench warrant that I was looking at. Ms. Feely, do you have good contact information for Mr. Hall? How do we know we can connect with him again, whatever our disposition is going to be? It sounds like it's going to be, this all needs to go away, but we don't know. And I want to make sure we don't wait another 14 years to find Mr. Hall.
I can get a phone number for him. I don't as of yet.
Okay. All right. Mr. Hall, when you got picked up, were you living in a stable place or were you bouncing from place to place? What was going on?
When I got locked up back in 2019, I was staying with I had a spot and I had a spot with my kids. So I went in two different areas, but I got a stable place now.
Have you been
with my cousin? I got used his address for parole. I just paroled out and I came here.
Okay, so it's not that you got picked up on the warrant as walking down the street. You, as Ms. Tucson just said, you just finished a sentence. Maybe it was the one out of Fayette or Forsyth.
Yeah, it was Fayette.
Okay,
And it's still active until July.
Got it. And so it wasn't that, so Mr. Hall just didn't get released. He got shipped to us because there was a warrant out there.
Yes, sir.
All right. So Ms. Feely, I'm a little less comfortable than saying, let's just let him out because he didn't get picked up from a stable situation. He got delivered from, maybe it's about time for him to get paroled. And it seems like we ought to clear all this up before he starts his parole.
That makes sense. The 2005 case does not have a disposition. I'm not sure. It was, I think Mr. Hall's understanding was that it was run with everything else.
It looks like it was a PTI. Ms. Nelson's been doing some digging, and what she shared with me was that it was a PTI, and then it was drug court, and he got terminated from drug court and went AWOL, and there was the bench warrant, and that bench warrant has finally caught up with him.
I had a bench warrant back in 2014 and had both of them.
So, but I remain focused on the fact that this is a 2005 case. And so it seems like it ought to wrap up, but I think we just ought to have a nice bow to put on it before we say, you're all done. So I don't know that we need to even worry about getting Mr. Hall on another calendar if we can just get clarity as to what remains in this case. And it may be that the state says, we're just null processing the charge against him, given that he did X years out of Forsyth or Fayette, and he's already done 28 days in connection with this bench warrant. Let me check one more thing. So this is an accusation. Oh, no, it's not just misdemeanor. So there are felony charges in it, but they do. Okay. All right. Mr. Jordan, how much time do you need to figure out what the state's going to do with what looks like an open case, just a real old case for Mr. Hall?
Your Honor, I believe that since Ms. Feely and I have been speaking about this, I believe by the end of the week, we could possibly come to a resolution on this case.
Okay. So Ms. Feely, why don't we just tap the brakes for a minute on Mr. Hall's matter? If by the end of the week, what you hear from Mr. Jordan is either nothing or, oh, we want to take this to trial or something along those lines, then we don't need to drag Mr. Hall back into a booth. I'll deal with the bench warrant. I'd like to leave it in place until Mr. Jordan has a couple more days to figure out what the state may do, because that may include dropping the case against Mr. Hall.
Yes, Your Honor. I'll continue to research also.
Great. All right, Mr. Hall, do you follow that? Do you have any questions about that?
You say they supposed to try to handle it within the end of the week?
Yes, sir.
So when will I be back in here?
So you may not have to come back to court at all. If the state tells me at the end of the week they're dismissing your case, then you'll be released because this case was dismissed. If they tell me something along the lines of, wait a minute, we want to take this to trial. This was a serious case, and yes, it's now 18 years old, but we still want to try it. Then I'll lift the bench warrant once Ms. Feely gives me good contact information for you, so that we know we wouldn't wait another 13 years to find you if we needed to move forward with the case. All right.
Okay.
All right. Thank you, Ms. Feely.
Thank you.
So, Mr. Hall, you're free to step out of the booth now. All right. Since we've got your speaker, oh, you're Mr. Neesmith, so we're waiting for Ms. Wood to come back.
Yes, sir.
All right, so sit tight. We'll get her back and we'll work through that. Let me mute that and work our way along. Ms. Feely, I'm going to ask you, or if there is a private attorney on the call, if we work through our plea and arraignment calendar, do you have Mr. Adams, position 2 and 3?
I do not. My next one is number 6, Mr. Bateman.
Okay. is position 5, is that a public defender case or is Ms. Green private counsel?
That is a public defender's case. It's Ms. Woods.
Okay, so then we get to Mr. Bateman, like you said. Let me find him. 6. Oh, he's supposed to be right there where Mr. Neesmith is. Mr. Bateman, if you're out there, can you wave your hand?
Seeing 5 South, Judge?
In booth 4. Mr. Bateman, are you in 5 South? Nope, that person's not waving his hand. All right, I don't know where Mr. Bateman is. It says on the email he's in 1 North 1, but that's Mr. Neesmith. All right. Mr. Evans, we're coming back to. How about Mr. Melnick? Are you on the call? Mr. Melnick has sought to withdraw from the Tuitt case. I thought he would be here for that, but
he was present earlier, Judge. I did see him.
I just emailed him. He was stepping away. He didn't see this case on his calendar. So I emailed him and let him know it is on and to sign back on.
Okay. I don't know how to invite a booth. What do you mean by invite a booth?
To add a booth, you just go to invite. Under participants, invite.
Okay.
Then you're going to put SHE.
Where do I put that in? Under room system? Or email?
Under Zoom rooms.
It doesn't, my 2 options are room system and email.
Okay, I'm going to take back the host and add right quick.
Okay.
Okay.
Mr. Jordan, have you had a chance to talk with Mr. Johnson about Mr. Holt's case?
I have not, Your Honor.
All right. Is anyone here for Mr. Holt's case? I'm going to see if he's out here, but Mr. Johnson is otherwise disposed for the foreseeable future. But this may be one of the booths we're adding.
It is.
Okay. All right. Come back to that calendar. Let's see. Ms. Feely, do you have any other cases on here?
I have on the probation revocation calendar, yes.
Okay, what do you got?
I've got the first 3.
Oh, I'm not host anymore, so I'm stuck.
Okay, just a minute, Judge. Okay.
Hey, 2 North Booth 1. Are you Mr. Bailey or Mr. Bostic?
Mr. Bostic, sir.
Hey, Mr. Bostic, I'm Judge McBurney. How you doing?
My, sir, you Happy New Year to you.
Same to you. Ms. Rivers, Happy New Year to you.
Happy New Year, Judge. How are you?
I'm well. How are you?
I'm hanging in there.
Good. You ready to go on the record with Mr. Bostic?
Yes, I am. I'm ready.
Excellent. This is position 1 on our revocation calendar. It's 15 SC 136238. Mr. Bostic, I signed a probation warrant for you on July 20th of last year. And the allegation is that you had committed a new offense in DeKalb County. Looks like it was a misdemeanor. Well, maybe one felony and one misdemeanor in June of 2020. That is what you are alleged to have done, which would be a violation of your probation if that's actually what happened. Ms. Tucson, how much time remains on Mr. Bostic's case?
He has 3 months and 8 days left.
Okay. Ms. Feely, is Mr. Bostic admitting to these allegations, denying them? Does he want an evidentiary hearing? How does he want to move forward?
We are admitting for probation purposes, Your Honor. I sent over to Mr. Jordan the NPGJ orders on a couple of the cases that were in DeKalb County. Mr. Bostic came from DeKalb County to Fulton. And so I believe Mr. Jordan and I had agreed to present to the court he's been in for 49 days, just a 49 days and close the case out. And I can tell you more about Mr. Bostic.
And would Mr. Bostic then go, I have a note here that he's got a hold for Dunwoody. Would he go back to DeKalb custody?
Unfortunately, I believe so. It's a loitering, like misdemeanor ordinance kind of violation, but they do have a hold on him. The other thing I sent to Mr. Jordan is I've been in touch with the case manager at Hope Atlanta, who did confirm that he has housing for Mr. Bostic when he's released. So I'm hoping that the pieces are in place that he can get his feet under him after he's released.
Okay, but your proposal is revoke whatever amount would be effectively time served and then release Mr. Bostic to his hold out of Dunwoody.
That's correct.
All right, Mr. Jordan, anything you want to add to that?
No, Your Honor. I did receive the non-presentable to the grand jury from DeKalb County. Given that Mr. Bostic only has the 3 months remaining, I do believe it is a fair resolution to revoke time served and go ahead and suspend the balance to close the case out. And hopefully he's able to handle his business in Dunwoody, and also hopeful with the housing that Ms. Feely sent as well.
Okay. Mr. Bostic, are you following all the things that we're talking about?
Yes, sir.
Do you have any questions?
Well, what the whole Dunwoody is talking about, sir?
What Ms. Feely talked about is that you may have a charge of loitering or something to that effect out of Dunwoody, and they want to see you to talk about that. So what would happen is Dunwoody police will come pick you up and you'd go to I assume a municipal court up there.
Oh, okay.
Right.
Okay. Yeah, I do. Yeah, Larry. Yeah. So what's my charge in the DeKalb County was the county prosecute, but that Larry came as misdemeanor, and that's still in the docket, right?
That's what it sounds like. That's exactly right.
Okay.
All right. So, Ms. Feely, was there anything more you wanted to add, or you felt like you covered it?
I think that's it, Your Honor.
Okay.
Judge.
Yes, sir.
One more question, sir. What's the time limit I'm done with to come get me for that charge?
It's a good question. I don't know how that works when we give another jurisdiction notice as to when they need to. But what I will tell you is this: if it is the end of the week, I say if it's Monday and you haven't been picked up, you should reach out to Ms. Feely because she could let me know, wait a minute, Mr. Bostic is still sitting around waiting for Dunwoody. And I can address that because if they haven't come to get you between now and Monday, then they're not coming to get you and they're going to need to find you a different way.
Okay, thank you, sir. I appreciate you.
Okay. All right.
Thank you, sir. Thank you.
So, Mr. Bostic, I find that you did violate the terms of your probation by picking up these additional charges in DeKalb County. I understand they've been resolved in a way short of full prosecution. Still not what should have happened while you're on probation. I will revoke 45 days of your probation. You'll get credit for time served, and I will ask probation to suspend the balance of your probation and close out your case.
Okay, thank you, sir.
All right. Good luck in Dunwoody. Ms. Feely, anything else on behalf of Mr. Bostic?
No, Your Honor.
Okay, Ms. Tucson.
To clarify, no, just to clarify, is it credit from time served from November 17th of 2022?
I'm not sure. When did Mr. Bostic come join us?
November 17th, 2022.
Yeah,
Yes, ma'am. You got the date just right.
20 days.
Okay, thank you.
You're welcome. All right. You're free to go, Mr. Bostic.
Okay, thank you.
And Your Honor, on position 2, Mr. Bailey, we were hoping to do something on that case today, but it's my understanding from Mr. Jordan, that's a special unit prosecutor who may need more time to look into the new charges.
Okay.
Your Honor, and I apologize because I don't think I was clear in the email to Ms. Feely. Since it had original gang charges, I just wanted to a little bit more time to speak with Reeves Howes in regards to his input on a probation revocation as far as a stipulation to that matter.
Okay. And is he more or less available, or has he been sucked into the vacuum down in courtroom 1C?
I'm unsure, Your Honor. I did speak with him via email. I understand that Mr. Bailey has at least 6 years remaining on probation. So even in the event where Mr. Howes doesn't have further input on the case, given that he has so much time remaining on probation, the state just wanted additional time in order to be able to negotiate with Ms. Feely and also get a little bit more familiar with the underlying offense, which is the fleeing and attempting to elude that's currently in Judge Edwards' courtroom.
Okay. Well, let's do this. Hey, Mr. Bailey, can you hear us? Oh, you're not Mr. Bailey. Where? So this list is less hopeful. Does anyone see Mr. Bailey waving his hand?
Judge, that is inmate Bailey sitting in 2 North Booth 4.
Oh, all right. That's, I had just unmuted it. 2 North Booth 4. Mr. Bailey, can you hear me?
Just give me 1 second. I have him to move over to booth number 1.
Okay. were you going to try to connect with Mr. Hiles today, or you needed time beyond today?
I needed time beyond today, Your Honor. And just to be clear, I spoke to Mr. Howes earlier via email just to see his input on the case. And I believe that it's not a stipulation that we could possibly reach today.
Okay.
Mr. Howes' response.
Okay. Well, we'll get Mr. Bailey in a place where we can interact and let him know that. Are you Mr. Perry?
Yes, sir.
Good afternoon, Mr. Perry. How are things?
Good afternoon, sir.
Ms. Feely, Mr. Perry, your case also?
Yes.
Great. Mr. Perry, I have three. Ms. Rivers, we need to go on the record, please, with Mr. Perry.
I'm on the record, Judge.
Okay. You are on the calendar for one case, but I actually have 3 probation warrants I signed all on the same day from April of last year. I assume we're going to deal with all 3, or maybe probation has expired in the other 2. But the allegation is that way back in 2020, you were arrested for battery, and you also hadn't reported for a while. They had trouble tracking you down. You had an unpaid balance and hadn't shown probation that you were working. You basically had unplugged from probation, and that's what we're working on. Ms. Feely, have you and Mr. Perry had a chance to discuss the allegations?
We have, Your Honor.
And what is it that Mr. Perry wants to do?
We were hoping to stipulate, Your Honor, I spoke with Mr. Jordan about this one as well. As best we can tell from the record, this is his first revocation. He did have some trouble. He did some prison time and had some trouble getting back on his feet initially, but he is working now. He's got 3 children and is in a long-term relationship. We would ask the court to consider the 56 days that he's served. He understands how important probation is at this point. So we would ask the court to, given that it's his first violation, sentence him to the 56 days that he served.
Okay. Is it your understanding that he's on the calendar just for one case or all 3 of these warrants? I don't want the other warrants to trip him up.
Yeah, I'll double check, but I think all 3.
Okay. Ms. Tucson, how much time is left in Mr. Perry's cases? Is it the same amount? I don't know if they were sentenced all together or what.
It looks like case ending in 151, 326, 327. They all expired November 8th of 25. So he has 2 years, 10 months, and 4 days remaining on all 3 cases.
Got it. Okay. Mr. Perry, what happened? You seem to completely unplug with probation.
And there is another case.
Upon my incarceration, the first probation officer I had, I notified her. She lost contact. My address was in Riverdale, and she was coming to see me like every first in the middle of the month. I was working. I was also like paying. I was paying. And upon my incarceration, she never I called her when I got out. Like when I was released from my incarceration, I was out on bond, and I called her and told her that I had contact with the law and whatnot, and from then on, she was telling me to turn myself in, and I had my kids on the way and stuff like that, and I was currently working and stuff like that. So it was upon me that I didn't turn myself in at the time because I wanted to be there to see my kids be born. I have 2 recent kids. Upon me being out these 3 years, I got 2 2-year-olds.
Okay. And where will you, the address we have for you, it sounds like is old Park Ridge Circle in Riverdale?
Well, when she didn't come see me, that's where I was recently residing at, but that would be my address now because since I've been in here, like the things I have gained, like from my job, like I lost like my house that I had now, like I don't have it anymore, so it would be me starting over. So
okay.
It would be the current address that I still could use right now.
Whose address is that?
It's my mother-in-law address.
Okay, 435?
Park Ridge Circle.
Okay, so she's still there and she would take you back?
Yes, sir.
Where are your kids?
They're with their mothers right now.
Okay. And are all the kids with the same mom or are there different moms?
Different mom.
Okay. So you wouldn't be living with one of them, you'd be staying with your mom.
Yes, sir.
All right. And what was the job you had that you think you lost?
Well, I had two jobs. When I'm not working at Fresh Express, the salad company, I had my next door neighbor, he had a fencing company that he would let me come and work with him like throughout the week and sometimes on the weekend.
Okay. Got it. Mr. Jordan, what are your thoughts about what ought to happen? It sounds like there's a fourth case, and I'll hear from Ms. Tucson about that in a minute.
Yes, Your Honor, that is correct. That was the negotiated stipulation that Attorney Feely and I came to. I understand that while Mr. Perry was gone for a long time, given that this is his first violation, we felt like this was a fair resolution, just stressing the importance of reporting to probation, and given that he has multiple years left on it, that he has a lot to risk if he continues to not report.
Right, unless he disappears for 2 years again and they don't toll it, and then voila. Okay, Ms. Tucson, what's the fourth case?
That is the one from Lee County.
Oh, okay. So I can't do anything with that. I didn't realize.
That one expires in 2024, but that's a different county. And wherever he lives, he'll be supervised on all four cases.
Got it. And Mr. Perry, the Riverdale address, is that Riverdale Clayton County or Riverdale Fulton County?
I actually don't know, but I would say Clayton County.
Okay.
That's Riverdale, Clayton County, Your Honor.
Yeah, it looks like it looks like it's Clayton. And because they sent it back to us for the revocation, you'll have to report to Fulton and then they'll send it back to Clayton. Okay.
All right. Mr. Perry, I do find that you violated the terms and conditions of your probation in a bunch of different ways. It's important that you reconnect with whoever your probation officer is going to be. And I think you were saying this, in the end, it's on you to reestablish that connection if there's a break because you get locked up or something like that. Maybe it was the Lee County case that got you locked up. But either way, in the end, it's on you to make sure probation can find you. It's not supposed to be a hide and seek game. I'm going to revoke 3 months of your probation. You'll get credit for all the time that you've been in. I will reinstate the balance. And Ms. You know where the Fulton probation office is? Is that where you originally reported, or have you always been reporting on the Clayton side?
They actually came to me first when I was released from prison back in 2019. So I know where the probation office is, though.
On Memorial Drive here in Atlanta?
Yes, sir.
Okay. Well, that's where you'll need to report. I'll let Ms. Tucson tell you when. I think it's 72 hours after you're released, et cetera. But that's going to take care of these 3 warrants. Mr. Jordan, anything else in connection with Mr. Perry's cases?
Nothing further from the state, Judge.
Anything else, Ms. Feely?
No, Your Honor.
All right. Ms. Tucson, anything you need to add for Mr. Perry?
No, just to clarify, that was 3 months and revoked 3 months credit for time served from which date?
What day were you arrested, Mr. Perry? Do you remember?
November 10th.
All right. November 10th, 2022.
Yes, sir.
Okay. And just make sure you report after they clear these warrants, report to 276 Memorial. They'll put everything in the system that you reported and they will transfer your case back over to Clayton where you will be supervised.
Okay. So that means I will be released from here now?
So you won't be released right away. You got a little more time to do. You and the sheriff's folks can talk about how they're going to give you credit. Okay.
Okay.
All right. Thank you. We have Mr. Melnick now, so I would like to switch over to Mr. Tuitt, which is 9, which is 6 South. Is Mr. Tuitt in 6 South Booth 1? That's not on our call right now.
Judge, I believe, I remember going to the 6th floor to speak with him. So I believe that's probably right.
All right, I'll add it.
He's been waiting in the booth, but since it wasn't connected, they put him back up. So give me a second. Let me get him back in the booth.
All right, thank you.
Thank you.
We are connected now, so that's good. And Mr. Shapiro, is this your case or Mr. Abate's case?
I'm sorry, Judge, what position are we on?
Tuitt is a murder. Okay. I know we've been bouncing around. The list isn't working out quite the way I thought it was going to work out. No, Mr. Holt. Okay. Mr. Whitenauer, what case or cases do you have?
Yes, Judge. I am here on the plea and arraignment calendar for positions 4, 5, and 6, and on the jail probation calendar, positions 5, 7, and 8.
Okay, you got plenty of stuff. We just haven't managed to hit any of those yet. All right.
Yep.
All right. Ms. Wood, you're back. Are you handling positions 7 and 8 on the revocation calendar?
One moment, Judge.
Those are actually mine, Your Honor, and that Mr. Williams is housed in Cobb County, and unfortunately I was not able to meet with him before today, so I would need to do a breakout session at the end of the calendar.
Well, why don't we, I'm gonna get him on the screen, and we're going to talk real briefly, and maybe we can get you two connected.
Thank you.
Sure. Just trying to get folks with multiple positions here. I go back here. Cobb. One. Mr. Williams, can you hear me?
Yes, sir. Good afternoon. How are you doing? Happy New Year.
Same. You know the routine. Whoop, don't take him away.
I've got somebody to hang out with all the time.
Hold on, we got to turn Amp's phone off there. Okay. Mr. Williams, I was just chatting with your lawyer, Ms. Feely, who wasn't able to connect with you in advance. Ms. Feely, you'd like to have a breakout with Mr. Williams?
Yes, I just would like to go over the indictment, then I can file a waiver today.
Okay. Are we able to do breakouts with Cobb Booths? Do we know?
No, I'm gonna provide a phone number in the chat so she can call and be able to speak with him.
Oh, fantastic. That's why the deputy came in. Okay. Excellent. Thank you. All right, so Mr. Williams, in a moment, you're going to get to talk on the phone to Ms. Feely, who is handling your two cases down here. She needs to chat with you a little bit before she can make an informed decision about waiving arraignment or not waiving arraignment. That's all we're doing today, but that we need to do that officially. So she needs to connect with you. When you guys are done talking about that, we'll get that official announcement, and then you'll be able to get back to whatever you were doing before they made you sit in that little room, okay?
Yes, sir.
All right. So Ms. Feely, it sounds like it will be a phone call outside the confines of this call. So I'm going to mute the Cobb booth and we'll move on to something else. And you can just call once they say you need to make that happen.
Thank you.
Great. In fact, there it goes. Excellent. Still no Mr. Tewitt, so we'll hold off on that. Booth 4. There we go. All right. Are you Mr. Askew?
Yes, sir.
Good afternoon, Mr. Askew. I'm Judge McBurney. How you doing?
Not so good, but I hope you're doing well. I hope you're having a happy New Year too.
Okay. Who is handling Mr. Askew's case on the defense side?
That is mine as well, Your Honor. He is at the Fulton County Jail, but unfortunately, I was not able to speak with him when I was there yesterday. So I would
Okay.
need to talk with him, and I actually have Mr. Williams on hold now as well.
Oh, I'm sorry. Okay. All right, then you can go back to Mr. Williams. Busy day for everyone. Mr. Jordan, this is your case.
That is
It's mine, Judge.
Oh, Whitenauer. Okay, I guess you said that, just doesn't say it here. And Mr. Whitenauer, we're not going to talk about the substance of Mr. Askew's case,
Yes,
but
Judge.
I've got down here that there was a bench warrant for Mr. Askew. Is that your understanding?
That's correct. He did fail to appear on this case, and a bench warrant was issued. He was picked up on that bench warrant, and he also has a hold from another agency.
Okay.
Mr. Judge.
Hold on, Mr. Askew. Mr. Askew, I promise we're going to talk about it. I'm just trying to get oriented, and we need your lawyer to be in the mix. She's just on the phone with another client. So we didn't end up doing arraignment. So we'll want to, at a minimum, work through that.
Yes,
Okay.
Judge.
All right. The hold is from where?
It is from, let me pull it up. It is from Riverdale PD.
Okay. All right. So, Mr. Askew, I'm gonna plug back in with you once we get Ms. Feely back, okay?
Can I ask you one question?
Yes, sir.
A bench warrant mean that I failed to appear to a court date that I was assigned to?
That's what it means. It doesn't mean it's correct, but that's what it means. It may have been that you were in another state. It may have been that you were in jail somewhere else, so you couldn't have made it here. But that's what Ms. Feely needs to tell me about.
This particular case was dropped on 9/2020 for lack of evidence when I was here. So I don't know how a bench warrant could be put out on me without me knowing it, because this case was dropped 2 years ago.
Okay, and that's what Ms. Feely and you need to tell me about. I'm not saying that bench warrant's correct. It's just a bench warrant. So that's what we're going to talk about, okay? All right. All right, is there any case we can move forward on right now? Who's got a case they want to talk about?
7 and 8, Mr. Williams.
Mr. Williams? All right, so that's going back to Cobb County?
Yes.
All right, let me get him on here. Mr. Williams, we're back. Did you have a chance to speak with Ms. Feely?
Yes, sir.
All right, Ms. Feely, Mr. Williams is on just for plea and arraignment today. What is the plan in moving his cases forward?
Yes, Your Honor, we discussed the process of what this court date is, and I will file a waiver and enter a plea of not guilty on his behalf, and he's fine with that.
Okay, he's got 2 cases. They are consecutively numbered. Does he have any other situation, or he just happens to be one of the inmates who's being housed in Cobb County?
He's just being housed in Cobb County for Fulton.
Okay. Mr. Whitenauer, any reason you will accept the waiver of arraignment? We'll get a scheduling order out for these 2 cases. Any reason why you think discovery is going to be complicated for you to get to Ms. Feely?
No, Judge.
Okay. So, Mr. Williams, what's going to happen next is that the prosecutor is going to give to Ms. Feely all the evidence he's got about your 2 cases so that she can sit down with you and sort out, hey, this doesn't look so good because this was caught on video, or why did they even charge you? We need to file this motion or that motion. And you and Ms. Feely will develop a plan for moving forward, whether it's we really want to work these cases out or we want a trial ASAP, and she'll start to make that happen on your behalf. But she's got to get that discovery first, and then she'll meet with you. Does that make sense?
Yes, sir. Ready to do.
Any questions?
I'm just trying to be free up out of jail. I go to
Okay.
college and I have kids I got to take care of.
Okay, we'll keep talking with Ms. Feely and she will help you work towards that goal, all right?
Yes, sir.
All right, you're free to go. Thank you.
Thanks.
Judge,
Yes.
we have a plea ready to go. I'm not sure if now is the appropriate time to request to take a plea, but I just wanted to let you know.
Excellent. I do want to do that. I would like to take care of Mr. Tuitt first. So I'm going to check again to see if he is in.
He's still not in the booth. The deputies are dealing with a situation on 6th South where he's housed. So it's going to be another moment before they can get him out.
Okay, safety first. That's fine. I appreciate that update. I know we got a few lawyers who we could free up if we tackled that, but we can't tackle that right now. So let me see. Are there any other attorneys who are on virtually who just have one case other than Mr. Melnick? Nope. Okay. Ms. Wood, I'm happy to turn. Are we talking about Mr. Evans?
Yes, Judge.
Okay. Remind me what booth he's in so I can make him reappear.
Oh, he's in the 1 North booth.
1 North 1.
Let me find him. I'm sorry.
Let me
Judge.
spotlight this. Nope.
That's not him. I'm sorry.
We also have a 1 North.
I actually don't see him.
Okay. He may have gotten disconnected. He's 8. That was 1 North booth ? On my email. So
Judge, maybe if you could activate 5 North.
oh, he's coming. He's coming. We got it. Excellent. Thank you, sir. Your bonus to, I think this is Mr. Neesmith. They're getting him. All right. Let me unmute that. 1 North 1. Hey, Mr. Evans, can you hear me?
Yes, sir.
Excellent. You should thank your colleague there who just fished you in here. Ms. Wood tells me that you're prepared to enter a plea in your case. Is that correct?
Yes, sir.
All right. Let me get Ms. Wood on the screen as well so that you can see her clearly. There we go. Excellent. So Ms. Rivers, we're going to take this down. This is position 8 on our plea and arraignment calendar, 22 SC 185320. Mr. Evans, in just a moment, Mr. Shapiro, who is right there, is going to swear you in. Once you're under oath, it's important that you provide truthful answers to the questions that he asks and I ask. It's just as important that you let me know if you've got any questions of your own. You can't hear what's going on, or someone says something that doesn't make sense or is different from what Ms. Wood told you, and I'll make sure to do my best to explain it. Or if you need to have a private conversation with Ms. Wood, we can put you into a breakout room, okay?
Yes, sir.
All right, when you're ready, Mr. Shapiro.
All right, thank you, Judge. Your Honor, I'll remain seated just so he can see and hear me if that's okay.
Works for me.
Mr. Evans, would you please raise your right hand? Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can lower your hand. Would you please state your true and correct legal name for the record?
Chaz Maurice Evans.
And are you currently taking or under the influence of any medications, drugs, or alcohol?
No, sir.
Is there any medication that you normally take that you have not taken or been given today?
Yes, sir.
And what medication is that?
Seroquel.
And that's one that you took today or did not take today?
I didn't take it today yet.
Okay. Does the fact that you did not take that medication affect your ability to understand these proceedings at all?
No, sir.
What is the medication prescribed for?
Mood swings.
Okay. How old are you, Mr. Evans?
19.
And how far did you go in school?
11th grade.
Do you understand that in this indictment, you've been charged with cruelty to children in the first degree and cruelty to children in the third degree?
Yes, sir.
And do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes, sir.
Do you understand that if you were to plead not guilty or were to remain silent and refuse to enter any plea at all, then the state would be required to prove those charges against you at a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about the charges in the indictment, including the facts and circumstances related to those charges?
Yes, sir.
And do you need more time to discuss the case with your attorney?
No, sir.
And are you satisfied with your attorney's services?
Yes, sir.
And Ms. Wood, being that this is plea and arraignment, are we waiving a formal reading for purposes of the plea?
So waived.
And are we waiving any defects in the indictment for purposes of the plea?
So waived.
Thank you. Mr. Evans, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, sir.
And do you understand that today you're entering what's called a negotiated plea, which means that the state is going to recommend the following sentence to the court? For count 1, cruelty to children in the first degree, the state is going to recommend a reduction to simple battery, that you be required to serve 12 months in custody and that you be given credit for the time you've already served. And for count 2, cruelty to children in the third degree, the state is going to recommend a reduction to misdemeanor reckless conduct and that you will serve 12 months of probation on your release. The state's further going to recommend that as conditions of that probation, that you have to be working towards successfully getting your GED, and you are not to have any further violent contact with the victim in this case. Is that your understanding of the negotiated plea you're accepting today?
Yes, sir.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, sir.
And do you understand that the court has the right to sentence you to the maximum possible sentence for each charge?
Yes, sir.
And do you understand that because there's multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively or one after the other?
Yes, sir.
Are you currently on probation or parole, Mr. Evans?
No, sir.
Do you understand that while on probation, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, sir.
Do you understand that you must follow all the special conditions of your probation, including the ones I've just described for the court?
Yes, sir.
And do you understand that if you fail to follow the special conditions of your probation, then you could be subject to a revocation of your probation for the balance of your sentence?
Yes, sir.
All right, Mr. Evans, do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, sir.
And do you understand that you're also giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if you were convicted of these charges at a trial?
Yes, sir.
Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, sir.
And is it your decision to enter a guilty plea because you're in fact guilty?
Yes, sir.
Mr. Evans, in indictment number 22 SC 185320, how do you plead to the reduced charges of simple battery and reckless conduct?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that if you wish to challenge the voluntariness or any constitutional aspect of your guilty plea, you must do so by filing what's called a habeas corpus petition?
Yes, sir.
And do you understand that because these are misdemeanor offenses, you will have only 12 months from today to file a habeas corpus petition?
Yes, sir.
All right, thank you very much, Mr. Evans. Judge, the facts of the case as indicated by the reports are that on November 4th of 2021, officers with the Atlanta Police Department and emergency medical personnel responded to 6535 Ashdale Drive in Fulton County in reports to a medical emergency. The officers met with the 8-year-old victim in this case, whose initials are TM, and his sister, whose initials are LM. Both children identified the defendant, Chaz Evans, as a relative of theirs, and both described that the defendant had left a knife in hot or boiling water and then dared the younger children to touch it. While TM's back was turned, the defendant picked up the knife and placed it on his right forearm. The EMS records indicate that this left approximately a 1-inch burn on his right forearm. The victim was treated on the scene by EMS, but was not required did not require any follow-up treatment at a hospital. The officer spoke with the defendant, who stated that he had touched the victim with the knife. He indicated that he had placed it on himself first. And since it was not hot to his touch, he didn't believe that it would cause a burn, that he didn't intend to burn the victim. The defendant was arrested on the scene. Judge, in speaking with Ms. Wood, as well as the father of the victim in this case, everyone seems to be in agreement that this was more or less a very ill thought out prank that unfortunately resulted in the child being burned. However, it doesn't seem that Mr. Evans had the malicious intent to cause any kind of injury to the victim. He's been in custody now for 426 days.
In connection with this?
In connection with this, that's correct, Judge.
So on November 4th, he was arrested?
Or
thereabouts?
On November 4th or thereabouts. I can tell you. And
that's okay. You don't need to. Okay. It'd have to be close to that, given the math. He was arrested close in time to the incident.
And he was granted a bond after, I believe it was 265 days without an indictment. He was granted an $8,000 bond. However, still remains in Fulton County Jail.
Okay.
And so
hence the 12 months. He served 12 months.
He has served over 12 months.
Okay.
Approximately 14 months, I guess, Judge.
Okay.
And so that is the reason for the recommendation. We've discussed it with the victim's family. And as I said, everyone seems to be in agreement about this resolution.
Okay. That makes sense to me. Ms. Wood?
Thank you, Judge. Mr. Evans is 19 years old. He was 18 at the time of this incident. He lives here in Atlanta. All of his family's here. He's able to return to live with his mom upon release. He is eager to get out, Judge, and work on completing his education. He was in the 11th grade at the time of this arrest. So he's been in, as Mr. Shapiro said, over a year. It seems like a dare. He was a kid at the time watching children. And so we appreciate Mr. Shapiro's willingness to work with us, and we ask that you accept the state's recommendation in this case.
Got it. Let me ask Ms. Livingston, are you, we switched. Is it Ms. Gordon now? I thought Ms. Livingston from pretrial.
Good afternoon, Your Honor. It is pretrial Officer Gordon.
Hey, Ms. Gordon, do you have any criminal history for Mr. Evans?
Yes, Your Honor. The record indicates the defendant has 5 cycles beginning in 2017. However, the first cycle is a juvenile cycle. Record indicates the last arrest was May 4th of 2022 out of Fulton County for first-degree arson and riot in a penal institution. Both charges were null prossed May 17th of 2022 under case 22 SC 18-18-87. Nothing further to add, Your Honor.
All right, thank you for that. Mr. Evans, do you have any questions about what Mr. Shapiro said about your case?
No, sir.
Were you babysitting the Minceys, or were you just sort of friends with them?
No, I was babysitting them because I go pick them up from school, and I watch them until my sister-in-law or their dad will come pick them up.
Got it. Where were you in high school?
Where did I go to high school? Where did I attend?
Yes, sir.
Riverwood Charter.
Okay.
And prior to that, I was going to Skyview.
Okay. And when you get released, you'll be able to stay with your mom?
Yes, sir.
Okay, got it. Well, Mr. Evans, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. The fact that you did not get your Seroquel yet, has that made it hard for you to understand, or do you feel like you've understood?
I've understood everything.
Okay, then I'll accept your plea to the 2 reduced counts, 1 count of simple battery and 1 count of reckless conduct. I'm going to sentence you on count 1, that's what's been reduced to simple battery, to 12 months in custody, but I'm giving you credit for all the time you've been in. In count 2, I'm sentencing you to 12 months probation. That's the reckless conduct. It'll be a special condition of your probation that you either provide proof of enrollment and participation in a GED program, or that you are working full-time, one or the other. You can do both, but one or the other. Are the Mincies, are they related to you? Because one of the conditions Mr. Shapiro asked for was that you have no contact with them, but if those are like your cousins or something, that could be complicated.
Judge,
Hey.
I'm sorry to interrupt, Judge, but the recommendation was just no further violent
No
contact.
further violent contact.
Given
All
that
right,
they do appear to be related.
got it. So you can't hit them, you can't put a hot knife or a cold knife on them, nothing like that. You can be around them, but just be smart about it, okay?
Yes, sir.
All right, Ms. Wood, anything else on behalf of Mr. Evans?
No, Your Honor, thank you.
Mr. Evans, you will be contacted either by Ms. Wood or by misdemeanor probation because you're going to need to meet with those folks just to get signed up for that program. And I will waive your probation reporting fees for the first 3 months of your 12 months of probation.
Okay.
All right, Mr. Evans, do you authorize me to have my staff sign the indictment for you indicating you've pled guilty?
Yes, sir.
Ms. Wood
Yes, Judge.
and Mr. Shapiro?
Yes, Your Honor.
All right, and so we're clear, count 2 runs consecutive to count 1. It's 12 months to serve, credit for time served, followed by 12 months on probation. And I think that's it. Thank you, Mr. Evans. You ought to get out in the next couple days. If it's Monday and you're still in jail, call Ms. Wood and she'll tell me and I'll call the jail and fix it, okay?
Okay.
All right, good luck with things.
All right, thank you.
Thank you, Judge.
All right, since we've got booth 1 still open, sir, can you remind me who you are?
Freddie Neesmith.
Mr. Neesmith, is that your case, Ms. Wood?
He's my judge. Actually, Mr. White and I are talking via email about Mr. Neesmith. Hi, Mr. Neesmith.
How you doing, ma'am?
I'm good, Judge. So we might have to come back to Mr. Neesmith if that's all right. I'm happy to do a breakout with him now, if that'd be better.
You'd like me to put you in a breakout with Mr. Neesmith?
If I'm trying to feel what's left on the calendar that's mine. I was hoping to have an offer from Mr. White now. We're going back and forth sort of, so.
So let's just keep Mr. Neesmith sitting tight. I will connect you, but we may be able to get some other gentlemen out of here. So Mr. Neesmith, it's good news. It sounds like your lawyer's making progress and maybe resolving your case today. So you sit tight, and I'm gonna get these spotlights off here, and I'm gonna mute your space, but I'll unmute it when we're ready to roll. And it may be that you and Ms. Wood drop into a breakout room to have a private conversation, okay?
Okay, yes, sir.
Great.
Thank you, Judge.
You bet. So I'm going to go back to the top of the calendar because I checked Mr. Tewitt's booth and still no one in there. Stanley Adams, is he your case, Ms. Wood?
He is, Judge. I do.
Let me get his booth then so he can join us 1 and 2.
Judge, if you can just check your instant message.
Oh, all right. Got it. Mr. Melnick, you are free to go. We're not going to be meeting with Mr. Tewitt today. And Mr. Abate, sorry to keep you here all afternoon, but when we don't have the whole world listening, I can let you know why Mr. Tewitt's not coming out, but that's not in the cards for him today. All right, thank you.
Thank you, Judge.
You bet, Mr. Melnick, but we will need you to join back in when we do get Mr. Tewitt to a booth or to my courtroom, just so we can complete the conversation that you started in writing about withdrawing.
Okay, thank you, Judge.
All right, thank you. And if there are family members of either the victim in this case or Mr. Tewitt's, I can't give you all the details other than that Mr. Tewitt declined to come to the booth today.
Gotcha.
Thank you.
Thank you.
All right, so you were going to say something about Mr. Adams.
Yes, Judge, I apologize for speaking out of turn. I have an updated offer for Mr. Adams' 2 cases, so I will need a breakout session with him to see if we might possibly be able to resolve these today.
All right, so I'm making a list here. Would you need breakout with Adams, and you may need one with Neesmith?
Yes, Judge.
All right.
And there's another position I need to also break out with.
Well, we'll get there. Let's just march through this so these gentlemen can hear it as well. Neesmith, we heard about. Mr. Reed, is that your case?
Judge.
Yes, Judge.
Hold on one second. Yes, Ms. Livingston.
I'm so sorry to interrupt. Stanley Adams is in the 5 North booth, and he's being inappropriate right now. So I have a deputy on his way to take care of him.
Got it. I just got a note about that. Thank you.
Okay.
So we'll reconnect with him later. So position 5, Mr. Reed, is that your case, Ms. Wood?
Yes, Judge, it is.
All right. Is that one we can do now, or is that also a conversation?
Judge, that is one we can do now.
All right. Let's figure out. That's 5. So that should be 4, booth 4. That one I have to do here. Hey, Mr. Reed, can you hear us?
Yes.
Good afternoon, Mr. Reed. I'm Judge McBurney.
Hey, how you doing, Jimmy Byrne?
I'm doing okay. Your booth is real dark. You got some mood lighting going on in there, but I can see you just fine. I'm just letting you know it's a little different.
What on him? I know I'm sorry to interrupt you.
That's okay. What was your question?
I went to court on December 14th, and they gave me a $40,000 bond with house arrest. What I'm here for now?
So I'm going to let Ms. Wood address that maybe. This is plea and arraignment. I don't think I've ever met you before. This is a case where you're charged with aggravated battery and 3 counts of aggravated assault. And we're just trying to move your case forward. I'll pull it up on my docket to see if there's more to it than that. But Mr. Whitenauer, do we have you plugged in as well?
Yes, Judge, I'm handling that case.
Great. So Ms. Wood, have you and Mr. Reed had a chance to talk?
We have not. Hello, Mr. Reed.
Hey, how you doing?
I'm good. Judge, I do want to let you know, I think he might be referring to, there's an open 22 CP case that may be the one that he's referring to about having the bond.
I think so, because this case, the one we're here to talk about, the indictment was in November, and there was a bond order entered in June of a $15,000 good bond by Judge Oliver. So there's a bond in place for this case, and that's a different case.
Yes.
So do you and Mr. Reed does that need to be one of your breakouts?
Judge, we can do a breakout. I don't believe this one will resolve today in light of that unindicted case, as well as there's a Monroe County hold. So I'm definitely going to need a little more time, but I am happy to speak to Mr. Reed about the process of waiving the arraignment today, Judge.
Okay, we will line that up as well. So Mr. Reed, sit tight. I'm going to just see if there's anyone else. Oh, something is loud.
Can I ask you a question?
You sure can. What's your question?
What the Monroe case is in Monroe?
Ms. Wood says there's a hold for you out of Monroe. I don't know. Do you know more about it than that?
I've never been to Monroe. I never know I had a case in Monroe.
Okay. Well, I don't know that you do either, but I do know that you've got this case that we need to work through, so if you know what arraignment is and you're comfortable waiving arraignment, we can just do that right now. If you want to talk to Ms. Wood for a few moments first, we can make that happen.
Yes, we can talk.
Okay. Well, what I'm going to do is actually do that right now, and then we'll turn to Ms. Feely's case, which is the next one on the calendar. So you guys are going to talk about arraignment and pop back in here when you are ready. So that's 4 South 4. right. Excellent. 6. So do we know where Mr. Bateman is? All
He's
right.
in 5 South Booth 1.
5 South Booth 1. Thank you. Let me see if I can. Hey, Mr. Bateman, can you hear us?
Yes, sir. I can hear you.
Great. Good afternoon. Your case is on for plea and arraignment. Who's handling this for the state? It says Ms. Charles.
That's 88 Wittenauer, Your Honor.
Oh, another Whitenauer special. All right, Mr. Whitenauer, your case. Mr. Bateman, have you and Ms. Feely had a chance to speak?
Yes, sir.
Excellent. Ms. Feely, what is the plan for Mr. Bateman today?
I've spoken with Mr. Whitenauer. This isn't something that we can work out today, so I did file a waiver.
Okay. Waive arraignment. So what's going to happen next, Mr. Bateman? And you've been patient and on all afternoon, so you're going to hear the same thing. Mr. Whitenauer will get discovery to Ms. Feely. She'll meet with you to talk about what the state's case looks like, and then you and Ms. Feely will figure out what's going to happen next, whether that is to file motions to suppress something or for a bond or who knows what. And I will see you next, either because there's been a motion filed or because you've worked your case out. And if it's not working out, then we'll get you a trial. But Ms. Feely needs to get that discovery first. Ms. Feely, I'm noticing there's a CP case for Mr. Bateman, but it's from 21. Is that something that that we need to be focused on, or is it related to this?
So when I looked up that CP number, it actually has been indicted at this point. So yeah, that's another reason that we wanted to just go ahead and waive today so we can wrap everything up at once if possible.
Okay. Do the charges in the CP case look like they are resolvable? Are they akin to these charges on the surface seem fairly serious? How does the CP case line up to these?
I think it is similar.
Okay.
Just double check.
Mr. Bateman, while Ms. Feely's looking that up, do you have any questions about anything?
What is the CP case, sir?
Oh, CP, it's an unindicted case, and Ms. Feely's about to tell you what the charges are.
So I double checked, and the CP number that's listed there, I believe, is still a CP number. The other one that I looked up is actually this case. It's one number off. So
Okay.
he does still have an unindicted case.
And what are those charges?
Similar.
Okay. So Mr. Bateman, you may have, and this is why Ms. Feely is saying, look, just give me a minute to look through this stuff and go meet with my client. You may have another aggravated assault, family violence, battery type case that has not been indicted yet. So you were arrested for, or charges were brought, but it's not indicted. And Ms. Feely's observation is it makes sense to try to work those out together rather than you work this one out only to find you've got a whole nother matter that you need to work through. So she'll come talk to you about that. You may have questions about it. She can give you more specifics, and more importantly, you can give her more specifics, because it may be they're all one and the same, and we need to get our records straight. Okay?
Yes, sir.
All right. You are free to go. Thank you, Ms. Feely. We'll get a scheduling order out.
Thank you.
Excuse me, Judge Honor, can you hear me?
Yes, ma'am, I can.
Hey, my name is Ms. Wright, Carlethia Wright. I'm the mother of Quintavious Wright and Cordarius. Are we moving forward with him today, or he's not coming out at all?
You're asking about Mr. Tuitt?
Yeah.
Yeah, I have been told by the sheriff's folks that we're not going to be able to move forward with Mr. Tuitt today. There were some issues with him agreeing to come out to be in this booth. So what we may try to do is have an in-person appearance where the sheriffs bring him over here to court. Some folks are more comfortable with that than going into a booth.
Oh, okay. Oh, his mental state. Oh, wow. Oh, okay.
Okay.
Okay. So are we allowed to leave?
Yes, ma'am. I promise we're not going to talk about your son's case again today.
Okay, thank you, sir. I appreciate that.
You're welcome. Thanks for sticking with us.
All right.
Excuse me, Judge.
Yes.
I was inquiring about Bateman. Is there any kind of way after he speak to her, would he come back in and speak to you today?
Mr. Bateman?
The one that the case that you just was speaking on.
No, because today wasn't a day where we're going to resolve this. What Ms. Feely explained was, given the seriousness of the charges, that she needs to spend some time both with the prosecutor and with the discovery before she and Mr. Bateman can figure out the way they're going to move forward.
Okay, so it will not be no release or bond.
Not today, no, but that may be exactly what Mr. Bateman and Ms. Feely talk about is, hey, let's file a bond motion, or I don't know, Mr. Bateman may already have a bond and it may be too high, and then it would be a bond reduction motion. I don't know his situation.
Okay, he's been waiting 2 years and no, he had never had one before.
Okay. Well, let me look one thing up. You're right. There have been a bunch of petitions for bond, but not an actual hearing on it. So that may be one of the first things Ms. Feely decides to do is to get Mr. Bateman. What's your connection to Mr. Bateman?
I'm the victim, and I wasn't pressing charges or anything.
Okay, you are one of the victims.
A daughter. I was trying to get him home too.
Got it. Yeah, I'm now looking at the indictment, and you are one of the victims, but we've got multiple alleged victims in the case. So anyway, you're asking smart questions, and you'll want to coordinate with Ms. Feely because she's the one who would decide, yep, I'm filing a motion for bond, et cetera. Okay?
Okay, would you have her to call me as well?
Her number?
I said, could you have her to call me?
Oh, she's right here. That's really up to you guys. I'm not going to get in the middle of that one.
I believe Mr. Bateman provided some contacts that I need to reach out to. She may be one of them.
Okay, sounds good.
Okay,
all right.
Could I get her number as well?
Is there a number you want to share, Ms. Feely, at this time?
Can I put it in the chat?
Yeah, ma'am, you are the Shanika Jones?
Yes.
Okay, so if you look in your chat, there'll be a number from Ms. Feely, okay?
Okay, thank you, sir. Thank you, Ms. Feely. Happy New Year, y'all.
You too.
Judge, we can't hear you anymore.
All right. Can you hear me now?
Yes.
Excellent. Are you Mr. Holt?
Yes, sir.
All right. Mr. Holt, Mr. Johnson, your lawyer, is in trial right now. And so Mr. Jordan, who's the new prosecutor handling your case, has been trying to connect with Mr. Johnson, but Mr. Johnson is stuck in a trial. So I needed to give you that update. We didn't bring you over here for nothing. We didn't know Mr. Johnson was going to get swept into this trial. But I'm going to ask Mr. Jordan to do his best to connect with Mr. Johnson. His trial may last a little while, and we may look to see if there's another lawyer we can get to help you out.
Excuse me, sir. May I say something?
You may, as long as it's not about the substance of your case.
No, sir. Every court date that I've had, I think maybe 4 or 5. I think it's maybe the 5th one. Every court date that I have, there's a problem with my lawyer every time. This is the 5th court date, and every time I come, my lawyer doesn't show up or he quits the day before. And
yeah.
This is just unfair to me. I have a son out there, and also, if you're interested, I have the correspondences with Ms. Lovelace via email that you were asking me for. I found them, but my last court date, I wasn't brought out to have my lawyer. Well, they changed my lawyer again, so I haven't reached my lawyer to give my lawyer the emails between me and Ms. Lovelace that will show you what I had going on while I missed my court date. And I haven't had a chance to give them to my lawyer because every court date that I've had, there's a problem with my attorney. This is the 5th one.
Okay. And I appreciate that you're keeping track because I know it's been several, and I don't disagree with anything you said. We had you a lawyer and that guy quit, and we got you Mr. Johnson, and none of this is your fault. I mean, you missing court, I'm not going to comment on. That's not what we're working through today. But I understand your point, which is why I explained that what we may need to do is figure out if we can get a lawyer to replace Mr. Johnson. Mr. Johnson isn't the issue, as in he's stuck. He is in front of another judge. Again, not your problem. And I'm not telling you that so you can feel better about it. But we clearly need to get a lawyer to give voice to your concern about why you didn't show up for court and see if that changes anything. And more importantly, you got to work your case out, either get you a trial or work it out. That's where we're stuck. So
can the DA tell me anything that they were discussing or that he was trying to discuss with him? Can he give me any idea of where my case is headed? Because me having a new lawyer, I heard that 5 court days straight. Can I hear anything other than that today, sir?
And may I say something as well?
Yeah, one at a time. So Mr. Jordan, who's the prosecutor now on your case, is new to the case. I don't know that I'm not going to speak for him, but I'm just letting you know that this would be the first time he's been here in connection with your case. Mr. Jordan?
Your Honor, I can specifically state to Mr. Holt that I served discovery. I made sure that Mr. Johnson has all the evidence for this particular case. To answer Mr. Holt's question, we have not been able to get into negotiations, but I am confident, given what's happened in the procedural history so far of the case, that we'll reach an agreement pretty soon, as soon as Mr. Johnson is free from the YSL case.
So your thought, and you're not committing to it, but your thought is this is not a trial. There's a way to sort this out.
That's correct, Your Honor.
Okay. So we need to get some of Mr. Johnson's bandwidth or work with the Metro Alternative Defender Program to see if they're going to backfill for him while he's on the YSL case. Okay. So that is something new, Mr. Holt.
That is something very informative, something very new, because my wife was back there. Hey, I love you. She comes every time. She just wants to know something. And I was willing to settle the case myself if that's possible. So that sounds like we can come to an agreement, and that's the best news I've heard. I've been sitting almost a year.
Okay. All right. Ma'am, did you want to add anything, or you had the same question and now you've heard something that is new and maybe a little reassuring?
My problem was with Mr. Johnson. Ever since he got on the case, it's been very hard to contact him. I have emailed him over 50 times. I have left over 50 voicemails. I'm not sure what's going on, but I have been reaching out. I even spoke with your young lady that you right here.
Yeah.
I even spoke with her. She even tried to get in contact with Mr. Johnson.
Okay.
And nothing.
Well, I appreciate you sharing that with me, because what I plan to do is to reach out to the folks who handle that staffing and flag this as one where maybe getting a colleague of Mr. Johnson's to stand in would work out, because it's a resolvable case. If it was going to be a trial, it's harder to switch up lawyers. But if it's something Mr. Jordan is saying, we could probably work this one out, especially given how long Mr. Holt has been back in custody again. We need not just a warm body, but it needs to be a lawyer who can spend a little bit of time with Mr. Holt, be responsive to your calls, and then connect with Mr. Jordan. And then maybe we take care of this. So my commitment to you all is to reach out to the folks who handle staffing on the kind of cases Mr. Johnson is handling, to see if there is a clean way of doing this, because Mr. Johnson's commitment to this YSL case could take a while if you've been following that at all. So
yeah, I was gonna say, but every time I even asked to speak with someone over him, it's the same thing. Leave a voicemail.
Yeah.
Get that with you.
Yeah.
Like I said, I just went over 60, 50 voicemails.
okay. Well, I will reach out. Hold on one sec, Mr. Holt. I will reach out, and I think contact from me might be a little different from contact from you, because it sounds like we can frame this not as we need Mr. Johnson for a trial. Lots of people need Mr. Johnson for a trial, but he's spoken for right now. It's we could resolve such a situation and get this young man out of custody. I think they'll say, oh, we'll get someone that way. I can't promise it, but what I can promise is that I will make that outreach. Okay. All right, Mr. Holt, anything else?
Is there a way the way that you said, like getting someone to step in for him? How do I go about doing that? Do I say I don't want to let an attorney, or
you don't do that. You let me reach out and see what I can do. And if I'm unsuccessful, then you may want to consider that, you know what? I don't want a lawyer. Let me talk to Mr. Jordan. I don't ever advise that. It's always wiser to have someone who is neutral and who knows the system. So when I say neutral, they'll be your advocate, but it's not you. You're desperate, and you may make a decision that's not in your best interest because of your kids and your wife, et cetera. So let me do that outreach, and I will report back to Mr. Jordan as to whether, yes, this is the person you can engage with, and then we'll get that person to connect with you, Mr. Holt. Okay?
Do you have a timetable for when I'll be back in court?
I don't want you coming back until we've got that person in place, because all I'll have to do is look at you again and you'll say, Judge, that's number 6. And we don't need number 6. When I have you back here, it needs to be you've got that lawyer in place who's ready to say, we've sorted this out. Now, I want to be clear. Mr. Jordan may say, I think this is a reasonable outcome. Your lawyer may say, I think it's reasonable. And you may say, screw it. And if you do that, that's fine. It's your choice in the end. But that's you saying no, thank you to an offer that was made. I'm trying to create the channel so you can get that offer. You need that lawyer who can be that conduit, so he can tell you, or she can tell you, hey, the state is offering X. And you can say, you know what? Offer them this in return. I don't quite like that. See if we can do this thing in the middle. And you may say, great, I love it. What that offer is, I want it right now. But there's no conduit. There's no way for that conversation to occur. Let me see if I can line someone up who will stand in for Mr. Johnson to resolve the case. And if I'm unable to do that, then we'll bring you back in person so that we can have that conversation about self-representation. You always have the right to represent yourself. It's rarely a good idea, but it may be in this rare circumstance that it is in your interest. You can say, you know what, I want to represent myself to the extent that I can sit down and talk with Mr. Jordan, see if I can work it out. But let me see if I can get this lawyer in place, and then you'll know it worked out because we'll be bringing you over here in person, okay?
Thank you, sir.
All right. Thank you. And thank you. What's your wife's last name?
Ms. Williams.
Ms. Williams, thank you for being here.
Call show.
All right.
Sure, I can share it with you.
All right. Ms. Feely, are we able to do Mr. Askew?
I need to do a breakout with Mr. Askew. He was
Okay.
the one I was not able to see at the jail yesterday.
Got it. And my sense from all this is that because it's the brand new year, just we weren't connecting with folks as well. Like we haven't normally had to do as many breakouts. And in general, I discourage that. But if it's new year and that's why we'll make all these happen. So where did my nice list go? It sounds like Ms. Wood, we ought to start your breakouts as well. Who do you want to? Oh, she was in a breakout. You were talking with Mr. Reed.
I'm back, Judge. There was an issue, so whenever he swapped over, there was no way for him to talk to me. I couldn't hear him, he was muted. I did explain to him about his Monroe County hold and the new case and why I think it's in his best interest to waive today our plea of not guilty. So he might still have a few questions, but I'm ready to move forward on him.
Okay, let's get him back in here and see what he wants to do. So that was 4 South 4.
And Your Honor, while you're handling that matter, do you mind if I step outside and speak to Ms. Williams?
I don't.
Okay, thank you, John.
Sure. Hey, Mr. Reed, can you hear me?
Hey, I got a question, Judge.
Sure. Before you ask the question, it sounds like when you and Ms. Wood were in the breakout room, she couldn't hear you. Were you able to hear her?
Yeah, I can hear her.
Okay. Are we able to go forward with the waiver of arraignment, or do you want to ask your question now?
I want to ask a question because it's 2 Reeds in my dorm. Is it Darius Reed or Curtis Reed?
Okay. That may be, but we've got, are you Curtis or Darius?
Oh, Curtis.
Oh.
Well, that would explain, like, you're the one like, hey, I've never been to Monroe County. Yeah, well, don't go there either because they may mistake you for your brother Darius. So you must have been wondering, like, aggravated battery, man, that's not me. I'm in here for whatever you're in there for.
This explains so much.
Yeah, do you mind getting old Darius? I don't know what the situation is, but it was nice meeting you, and it may be that I've got your case, but on the calendar is Darius Reed.
Yeah, I like Monroe. I never been to Monroe.
Yeah.
I can have the deputy go get him for y'all.
Thank you. That would be great. Sorry to have wasted your time.
All right.
Take care. That's funny.
This explains so much, Judge.
Yeah. He's shaking his head like, what are you talking about? Let's see. We haven't talked about Mr. Gunnell at all. Can we do that?
Yes, Judge. I did speak to him before court today, and Mr. Jordan and I have been sort of working on something.
He is 4 South 1. Let me see if we can get him in here. There he is. Mr. Gunnell, is that you? Great. Let me unmute you. Oh, I think we got you. Can you say something?
Yes, sir.
Excellent. How are you?
How you, Judge? I'm fine.
Good. This just says inquiry calendar, Ms. Wood. Tell me why you think we've got Mr. Gunnell with us.
Judge, he was picked up on a bench warrant. He's been in a little over a month on that bench warrant. Mr. Jordan and I have talked about a resolution. I talked to Mr. Gunnell this morning about it, and I think we're pretty close to being able to resolve this one. So I think I would need a breakout session with Mr. Gunnell.
Okay. We'll do that. Where would you like to start? Adams, Neesmith, or Gunnell?
Judge, it turns out Mr. Whitenauer and I are going to need a little more time on Mr. Neesmith.
Okay.
So that one might just be the easiest one to do first.
So, but you would like a breakout with Mr. Neesmith?
Sure, Judge.
Okay. Let me find him. Arraignment. Oh, all right, so Mr. Gunnell, we're going to leave you for a minute. Ms. Wood needs to talk to you about maybe resolving your case, okay?
That's fine, sir. That's fine, sir.
Good. There he is. Hey, Mr. Neesmith, how you doing?
All right, sir.
We are going to put you in a breakout room with Ms. Wood to talk about your case, okay?
Yes, sir.
All right. There you go. Ms. Feely, what can we do right now with your clients?
The only one I have left is Mr. Askew, position 5, and he was the one that I was not able to see yesterday at the jail, so I need to briefly talk with him.
Great, let's do that. Let me find him.
It looks like 5 South Booth 4 is waving his hand.
Okay. Appreciate it. I need that extra set of eyes and ears.
Of course.
And an interesting day.
And I need to make sure that he's unmuted before we go into the room, because I think that's caused issues before.
Yeah. No, you can't do that. All right, 5 South Booth 4. Hey, Mr. Askew, can you hear us?
Yes, sir.
All right, I'll put you in a breakout room with Ms. Feely, all right?
Thank you very much.
You're very welcome. It's not letting me make a new room. That's not convenient.
Can I go to another booth?
No, you're good. It's just the only room I can send people to is the one that Ms. Wood is in with her client. And it's not letting me make a new breakout room, which it's supposed to.
Judge, can I ask you a question though concerning my case? They said I had a bench warrant. What was my supposedly court date that was?
I don't know right now. Now isn't the time to ask me that. Just because I'm trying to make this work. Ooh, they're done. Excellent. Let's move. Hey, Ms. Wood, are you done?
So I'm back.
Yes, Judge.
Okay, good. Sorry about that, Ms. Feely. I'm gonna put you back in room 3. I can't figure out right now how to make more rooms. So I sent you the only one I could accidentally. I'm gonna move you and Mr. Askew into room 3.
Thank you.
Sure.
So go to booth 3?
You don't, no. You don't move. You physically stay put. I'm moving you to a virtual space.
Sorry.
All right, so Ms. Feely, I'm moving you and Mr. Askew now.
Perfect.
I think. Let's see. It's not working well. Yeah, can you move to booth 1, Mr. Askew, please? Thank you. Hey there, can you hear us?
Yes, sir.
Excellent. Let me see if I can get you in the room. Sweet. Okay. Ms. Wood, what can we do with your cases?
Judge, for Mr. Neesmith, I am ready to waive formal arraignment and a plea of not guilty. He does seem to have some questions about why I think that's in his best interest today. Unfortunately, when the clients have been popped over, it's muting them. So I wanted to let you know I can go ahead and waive on him.
All right, well, let me get him on the screen. So that is 1 North. Hey, Mr. Neesmith, can you hear us?
Good evening, sir. Yes, sir. Happy New Year, sir.
It's not happy for me anymore. It's been a long afternoon, but Ms. Wood is.
She wasn't able to hear me. I was just hearing her like speak. I wasn't able to say anything, and I told her it was okay that I speak freely to the court. Is it okay that I speak freely to the court? I don't
So two things. Hold on. Yes, hold on. 2 things. One, we're having technical difficulties, so it wasn't Ms. Wood's fault that she could not hear you. I don't know why the system is being a pain in the behind, but it is. So I appreciate your patience with that. In terms of speaking freely to the court, you can share certain things with me. What you should not do is talk about the facts of your case, because the prosecutor is on the call as well, and he's going to say, oh, wait a minute, Neesmith said, I didn't shoot her, I just stabbed her. And he just admitted to stabbing her. So don't talk about the facts of the case. If you want to share with me, you're frustrated that you've been in jail this long, or you wish the food was different, or you miss your kids, something like that is okay to share with me, but you don't want to talk about the specifics of your case. Does that make sense?
Yes, sir. Yes, sir.
All right, lay it on me.
Okay, what I want to explain to you and her, because she wasn't able to hear me, that I've been incarcerated since September the 1st of 2001. I was arrested for this warrant September the 1st of, that's been like 14 months ago on this charge right here. And I was hoping to get it resolved today. She said she just got my paperwork today, and the DA had came up with an offer. And she said they was like, he haven't made an offer because I have like a similar charge in the DeKalb County. Well, I was holding for a whole year in Gwinnett County on a forgery charge. And they took me to DeKalb County and upgrade a simple battery that I had on my ex, and made me like make a plea to like time served and sent me back to Gwinnett County, and I was finished serving out that year and ended up getting time served and had to leave there and go to Monroe County And when I left Marlboro County, I had a warrant here for my fiance, which is like she already has done signed affidavits. It was like a big without standing, with no injury, no police, or injury or nothing like that. It was just like she was mad at me. I won't talk about the case, but just say she was mad at me, and she done talked to the DA and everything. And I just wanted to like the lawyer, like she was like wanted to like plead not guilty and come back another week. But I want to know I want to resolve this today, so I can get out of this stay with my mom. I stay with my mom. I'm helping her, and since I've been gone over 14 months, it's been going real bad. She's real sick, and they was looking for me to get out today, so I can get out and help her. Me and the victim, Latonya, we don't have nothing, no issues or nothing like that, sir.
Okay, I'm hearing you. I'm gonna slow you down a little bit. I understand a lot of what you're saying. It sounds like you got a lot of cases rattling around out there. What I heard Ms. Wood say is that what she thought she might be able to get for you from the prosecutor, she's not able to get for you right now. So it's not a Ms. Wood thing. It's the state isn't necessarily interested in having you pop out today. So what Ms. Wood wants to do is get the discovery from the prosecutor, which he will need to give her if we handle your arraignment today. And so where we are now, the simple question is, do you want to be formally arraigned, which means I read the indictment, tell you the consequences of the charges, et cetera, or do you waive arraignment, which means you're still saying not guilty, and it doesn't mean you don't want to work the case out. It means that you just don't need me to read all the charges into the record. And then Ms. Wood will get that discovery, and she'll get with you and either talk about bond or like you're trying to do, let's just work this thing out so you can be on your way. That's what we're working through today. She was hopeful, Ms. Wood was hopeful that maybe we could resolve it today, but that's not in the cards. And that's not a Ms. Wood decision. And ultimately it's not a you decision. The state has to be interested in whatever it is Ms. Wood was offering from your side. Does that make sense?
Yes, it makes sense, sir, but I haven't like talked to no one. I've been here since I've been here in this jail since September the 1st, going on 5 months.
See, you got booked in on, I have it as the 2nd, but either way, round about the beginning of September. You were not indicted. You were not indicted until late November. And so this is the first day you've hit my calendar. Ms. Wood is on the case. And she's not running from the case. She just is trying to catch up to what's going on. So she'll get the discovery and she'll meet with you. No one is interested in making this go any more slowly than it has. I'm anxious. If there's a way to resolve this soon, let's do it.
Can she talk to the DA now? I'm not a bad person, Your Honor. Okay. Can she talk to the DA like now and put me on hold and they can come up with something? Because I'm not a bad person, Your Honor. I'm trying to get out there and help my mom and do the right thing, sir. I don't do no drugs or nothing like that, sir. I got you. I've been out there 15 months. Everybody was counting on me to get out so I can help pay my mama rent coming up next month.
Okay, well, the 15, we're going to stop our back and forth. The 15 months isn't on us. I don't know what the 15 months is you're talking about. We got you in September, so that's 3 months.
I was arrested at work for this warrant in 2021 of September the 1st. I just had a hold for this warrant from Fulton County, but I resolved when I got to resolve when I had in Gwinnett. Fulton County had the hold on me for that warrant.
Okay, got it. Ms. Wood, it sounds like Mr. Neesmith is pretty anxious to work the case out. I know you will assist him with that. For today, though, it sounds like waiving arraignment is the most efficient way forward. I'm happy to formally arraign Mr. Neesmith, but if you and he have talked about it and you're comfortable with a waiver of arraignment, then we'll get the scheduling order in place and we'll get Mr. Neesmith back in here as soon as you and he have worked something out. But that, of course, requires the prosecutor to agree with whatever the recommendation is, or maybe it's a blind plea, who knows? But it sounds like Mr. Neesmith has banked a lot of time that could be credited towards any resolution in this case. And he's helped me understand that. And it sounds like Mr. Whitenauer understands it as well. So are we waiving arraignment from Mr. Neesmith?
Judge, we'll waive arraignment. I will enter the paperwork and get a substitution of counsel in, and I've inform Mr. Neesmith he's at the top of my jail visit list for the end of the week.
Okay. Mr. Neesmith, as soon as this case has been resolved, and again, it's not just you and Ms. Wood, it's the prosecutor as well. We'll get you either virtually, if that's sooner, meaning like this, or in person. We'll get you brought over and we will do what we need to do to close out the case. All right?
Yes, sir.
All right. Thank you both. You're free to go.
All right.
All right. Let's figure out what else we can work on. Mr. Reed, is that someone we can get back? Oh, we had the wrong Reed.
Yes, Judge.
So let's
I
look.
think you have the correct one now, Judge.
Okay. And that is number 5, 4, booth 4. South booth 4. Hey, are you Darius Reed?
Yes, sir.
Not Curtis Reed.
Yes, sir.
All right. Poor Curtis Reed was so confused. Darius Reed, would it surprise you to know that you have a hold out of Monroe County?
No, sir.
Okay. It confused Curtis Reed no end. He'd never been to Monroe County. He thought we were making stuff up. And then he's like, hey, wait, there's another Reed in my dorm. Darius Reed, you are here for arraignment. You've been charged in this indictment with aggravated battery and a few counts of aggravated assault, a few other things. Ms. Wood is your lawyer. Let me get her on the screen here. She's right there. We've got the prosecutor on the call as well. And I know you and Ms. Wood have not spent a lot of time together, but we're not making any formal commitments today. It's just deciding, do you need me to read all these charges into the record, or are you comfortable having Ms. Wood enter a plea of not guilty for you now? She'll get discovery and meet with you and figure out the right way forward.
Judge, I am comfortable waiving arraignment today. As I was talking about earlier, Mr. Reed has the Monroe County hold as well as the open unindicted new case that I'll need to dig into as well. Mr. Reed, I will be out to see you at the end of the week to go over all of this. So I would advise we waive formal arraignment, enter plea of not guilty. I'll get all the paperwork in today.
All right, no problem.
Okay, that's what we'll do. So, Mr. Reed, you haven't given up any rights or anything like that. It just moves your case forward. And Ms. Wood, by the time she comes to see you, will know a little bit more about your unindicted case. So that's not Monroe County. That's something else here in Fulton County. And then she'll start to get discovery in this case, the one you're indicted for, and she'll be able to share that with you as it comes to her. Okay?
Oh, appreciate it.
Mr. Whitenauer, anything from the state on the correct Mr. Reed's case?
No, Judge, and for all these cases, I've now that I know which that these defendants are being represented by the PD's office, I've asked my legal assistant to prepare and serve discovery.
Fantastic. Okay, thank you. You're free to go. Thank you for joining us. All right. I think is Ms. Feely still in the breakout room? Looks like it.
Well, I'm back, Your Honor. But Mr. Askew was muted. So I think he does still have some questions for me, but I will have to see him at a later point in time.
Okay. Let's get him. Oh, he had to move to booth 1. Right. Okay. I think we've got it. He's going to rejoin us in 5 seconds. Oh, he went back to booth 4. No, stay there, stay there. Okay. Hey, Mr. Askew, can you hear us?
Yes, I can hear you.
So once again, the system let us down and you were muted while you were in the breakout room. Not Ms. Feely's fault, but we just need to figure out how we're moving forward on this. You've got a hold from Riverdale PD, and I know you were wanting to talk about missing court and all that. Ms. Feely, tell me where you are on behalf of Mr. Askew, and then I'm happy to hear briefly from him.
Yes, Your Honor. So I did reach out to Mr. Whitenauer about the bench warrant. He missed court on October 7th, and I need to talk with him in more detail privately about that when I go see him. But I will file a waiver today and a motion to recall the bench warrant, and hopefully we can get him in for a hearing to address the bench warrant soon.
Okay. Hold on, Mr. Askew. Hold on. I'm going to hear from you as well. So waiving arraignment because we didn't get to arraign Mr. Askew because he was not in court on October 7th. Is that right, Ms. Feely?
Yes, Your Honor.
Okay. We'll get a scheduling order in place then. Mr. Whitenauer will get you the discovery in this case so you can share it with Mr. Askew. And it sounds like you will right away be filing something to lift the bench warrant as well. But understandably, you and Mr. Askew need to talk about it so he can tell you why he thinks the bench warrant was in error. All right, Mr. Askew, what is it you want to add to this?
First of all, I have never been to any court. I don't even know who this charge is against, who's supposed to be the victim. I've been working for 6 months, and all of a sudden I save up my money to buy a new car, and I'm pulled over. They say I got a warrant. I did have a charge 2 years ago here that was dropped for lack of evidence. So I don't know. I never had a court date or anything like that. I had never been contacted by any type of court. I've been working for the last 6 months, staying out of trouble. So I don't know who the victim is or actually what I'm charged with. They just said aggravated assault and domestic violence. Don't I supposed to have a chance to know who the victim is, or don't they supposed to show up at the arraignment or whatever? I don't know.
No, but hold on. All right, stop. So this is fitting together a little bit better now. Your indictment charges you with aggravated assault, and the allegation is that in September of 2020, so it's like you're saying it was a while ago, you did some things to a Ms. Freeman. So that's what you're charged with, is assaulting Ms. Freeman, but it's from September of 2020. The address that was in the system for you was on Joseph E. Boone. Is that where you were living when you got arrested?
That's where I work at. I never received nothing about going to court. That's my job.
Okay.
I work for the Atlanta Harm Reduction Coalition, and that's my job. I got all my mail transferred there. So I'm actually at my job, I'm in charge of mail. I distribute the mail, I put it in the box. So I know I would see a letter coming to me for mail because I'm the one in charge of the mail at my job.
759 Joseph E. Boone?
Yeah, that's the Atlanta Harm Reduction Coalition. And furthermore, back on the 20th, the case was dropped. Nobody contacted me, nothing about the case was picked back up. It was 2 years ago. Nobody told me anything about nothing about the case was picked back up. So how would I know I was supposed to be in court? And nobody ever sent me a letter saying that I was supposed to be in the court.
What about the address of 2409 Sandfall Court?
That's my parents' address.
Do they still live there?
Yes.
Okay, well, you got a letter telling you to come to court. The court date you missed, it was sent to 2409 Sand Fall Court. I got a copy of it right here.
Okay, let me ask you, so what was it? Was that letter informing me that my case had got picked back up?
It informed you that you needed to come to court. So
if I would have got that letter, I would have come to court because, like I said, I've been working. You can call my job. I've been diligent. I've been a public servant too, helping people with drug problems, with needles, trying to stop all kinds of stuff. I got a good record. It's the best job I ever had.
Good. Got it. Well, I'm glad. I hope you were able to plug back into that. But now that I see the pieces here, you did get notice. It went to the address you had provided, which was your parents' address. I don't know why they didn't tell you, or maybe you're just not remembering it, but you did get notice. That doesn't mean I'm not comfortable setting aside the bench warrant. That's why you and Ms. Feely need to talk about it. And then she's going to file a motion on your behalf, and we can have a conversation where Ms. Feely knows more about it and the prosecutor knows more about it. Okay. You also have a hold from Riverdale. So even if I set aside your bench warrant, you're not going anywhere other than Riverdale's going to come pick you up.
No, they're not, because that Riverdale thing is, my brother already admitted it. It's an open container charge. I never got arrested there. He gave him my name. I've never been to Riverdale. I've never been to Clayton County. So I've been on the computer trying to clear that charge up ever since I found out it was there. They won't answer the phone enough.
But it is still in your name until your brother does the right thing or you clear it up. You'd have to go to Riverdale anyway. I just soon keep you here and sort these things out. So that's how we're going to handle it for now. I am ready once Ms. Feely and you have had a chance to talk to entertain her motion to set aside the bench warrant. She also can help you with this Riverdale thing if it is what you say, that your brother used your name. But for now, it's in your name, not mine and not your brother's. And so it's holding you as well.
Can I talk to Ms. Feely now?
Nope. But she will come see you.
Can I ask her, how do she know? Can she have any indication when she'll be able to come? Because this is the reason I'm asking, John, is because that job I got is I have a record, and they took a chance on me, giving me this job. It's the best job I ever had. It's for the community, and I'm in the process of actually losing it if I can't get out here pretty soon. Because I've been talking to them every day, and they say they need that position filled.
I don't want you to lose that job, so I'm anxious for you to get back out there if that's the right thing to have happen. I'm confident Ms. Feely does not want you to lose that job. And so she will work on your behalf. Ms. Feely, what's your best guess as to when you could be out to see Mr. Askew?
That is a great question.
I guess a lot depends on what happens tomorrow when we call the trial calendar.
Exactly. And I expect that it will be not freeing up my next week, unfortunately.
Yep. Okay.
Or not unfortunately, but unfortunately for me seeing Mr. Askew. So it may have to be after that.
Okay. Mr. Askew, next week is a trial week in my courtroom. So the latest Ms. Feely will come see you would be the week after next. But if her case is not called out for trial next week, then she could see you either late this week or early next week. I won't know that answer till tomorrow.
You say the latest about a couple of weeks?
Well, not a couple, less than that. It would be a week from Monday or Tuesday.
Well,
okay.
Thank you for listening, Judge. Thank you, Mr. Fink. I couldn't tell what the name is, but thank you.
All right, you're welcome. Take care.
All right.
All right. What can we do next? We still have Mr. Bailey. We have Mr. Gunnell. And Mr. Adams, although something funky was happening with him, I don't know if he's back. And then we'll deal with Mr. Walker in about 15 minutes. So what do you all want to do?
I would like to be excused.
Well, all right then. So you don't have Bailey. That's a gang case. And you don't have Gunnell. So thank you for your time. Good to see you in this new year.
All right. Thank you, Judge.
All right. Let's see. 7 on plea and arraignment. That's Mr. Walker. We haven't forgotten you, Mr. Walker. Don't worry. So what else can we do now? We've got someone in 2 North Booth 1 who's been super patient. Let's figure out who that is. Hey, 2 North Booth 1, remind me who you are.
Calvin Bailey.
It's Mr. Bailey. All right. Ms. Feely, I think we just had a disconnect and weren't able to close the loop with Mr. Bailey. We are resetting that because Mr. Jordan needs to talk to Mr. Hiles.
Yes, Your Honor, and to possibly review further the underlying matter that he has, which is the fleeing and attempting to elude, which is the basis, I believe, for this probation revocation.
Got it. So I got his warrant right here. And that's with Judge Edwards. So it's been in, well, no, but he's listed a DeKalb series of arrests, but he's got a case with Judge Edwards here.
That's correct, Your Honor.
Okay. So you need to look at the case with Judge Edwards. You need to confer with Mr. Hiles about Mr. Bailey's gang situation, which are the underlying charges. This is what he's on probation for.
Correct.
Because right now, what Ms. Feely has suggested as a possible outcome, you're not comfortable with and want to get that additional input.
We did not get that far, Your Honor, but I believe, given the communication with Mr. Hiles, that it wouldn't be something that Mr. Bailey would be willing to stipulate to today.
Got it. Okay. So the way I'm reading between the lines, yeah.
What is the I won't be stimulated to today?
Well, I don't know if Mr. Jordan wants to say that. What I was just going to share with you, what I read between the lines is that the state wants you to serve some meaningful time as a revocation, and you may not be interested in that. And the state's got to prove you violated probation. A lot of times with these, the defendant says, look, I'll admit I violated probation if it gets me out. And what I'm hearing from Mr. Jordan is it's not going to get you out, that the state is going to want you to be revoked for a while. And you and your lawyer may decide, well, then we're not going to admit to anything. You got to prove that something happened. And of course,
one thing,
yeah. Yeah.
I was on parole when I caught the fleeing case, and I had a charge in the cab, and I had ran my parole out right here. They violated me, and they made me do the remainder of my parole. And I went to the cab. When I went to the cab, I got out. They violated me for going to the cab, but I caught both charges on parole.
Okay.
So they violated my parole because they don't violate me for probation. That's what I'm saying.
Oh, why would you get both?
Yeah, because I was on parole. I had both of the charges, and I came to jail, and they violated my parole and made me do the remainder of my parole. That was 100 days. Then I went to the cab. I burned out of here and burned out of the cab. And I went home. I was out a month and a half. And then they violated me for the cab charge. But I'm telling her, I was on parole, and they violated my parole for that charge. Okay,
I'm hearing you. And to be clear, the warrant I signed refers to the DeKalb cases.
Yeah, but I was on parole. I had both of the charges when I came to Wright Street.
I got it. Yeah, no, I'm hearing you. I'm talking to now the prosecutor.
They violated me 2 times. You violated me after I ran my parole out and went to the cab. I never got out. I was explaining my probation officer. I never got out of jail. I went from jail to jail. Got it.
I got it. So it may be that there ought to be an additional warrant because this does not reflect the Judge Edwards case. So it sounds like either way, you'd want more time to see if there is an offer that would be of greater interest to Mr. Bailey. And Mr. Bailey's point may be a valid one, that he's already been dealt with in connection with the DeKalb charges.
Yes,
right. We'll need to clear all that up.
Confer with Ms. Feely about all of those extenuating circumstances.
Okay, got it. So Mr. Bailey, the prosecutor is going to talk more with his colleague who is in the gang unit. He also needs to sort out this decab thing you've been talking about. And your lawyer needs to understand a little bit about what's going on. You've got a case in front of my colleague, Judge Edwards, which may become a basis for revocation. Let me ask Ms. Tucson, how much time is left on Mr. Bailey's case, this 16 SC case?
There is 3 years, 4 months, and 11 days remaining.
Okay, so it's not a 3-month thing where why are we splitting hairs? Okay.
It's just about the cam thing. I got violated my parole for that. That's all I'm saying. I'm just trying to get home to my son. You can do, I do intensive probation, whatever y'all want me to do. I just want to get home to my son. I got a brand new son. He's 5 months. I need to be home with him to help my fiance out.
Okay, well, first, congratulations on the brand new son. Is that your first kid?
This is my first child. I'm 29 years old.
Wow. All right. Well, I'm happy for you on that. Ms. Feely is going to need to talk with you and is going to need to talk with the prosecutor before we can figure out what we're going to do next. But before you despair, it's not like I'm going to not see you for 2 months. This is one that we ought to be able to sort out pretty quickly. Either we agree that there is no negotiated resolution and we have a revocation hearing where the state has to prove something up, or like you said, you already got your parole revoked for the decab thing, and
I got my parole revoked for the fleeing case over here and the decab case.
Yep, that's what I'm hearing you say. So we'll need to get some clarity on that. Okay.
Because I never got out. I was explaining my probation officer. I never got out of jail. I went from bond here and bond there.
All right. Well, Ms. Feely, you've got some things to work with on that one, and then let's get Mr. Bailey back here pronto.
Yes, Your Honor.
Thank you. Anyway.
All right, Mr. Bailey. Pardon me?
Yes.
We will see you real soon to sort out this situation with the decab and the Fulton charges, okay?
Yes, sir.
All right, thank you.
Thank y'all.
Mr. Adams is going to have to be reset.
Thank you, Judge.
You bet. So we are in the home stretch. That leaves on this first calendar just Mr. Walker, and we're going to handle him. And then on the second calendar, only Mr. Gunnell. So let's sort his situation out, assuming he's still around. What's up? One. There he is. Hey, Mr. Gunnell, how you doing?
Doing fine, y'all.
All right, very patient. Ms. Wood, tell me what's happening with Mr. Gunnell.
Judge, if the court will allow us to just have a very quick breakout session. When I spoke with Mr. Gunnell earlier today, I did not have the offer solidified with Mr. Jordan. And so I have spoken with Mr. Jordan since then. And so I would like to see if we could try to resolve this today.
Okay, that would be great. However, I will put Mr. Gunnell in the breakout room and he will likely be on mute, even though I send him in there not muted. So why don't we agree on a, hey, thumbs up if you agree with something, thumbs down. Like if you guys could just now while you can hear each other, agree on a sign language you're going to use.
Understood, y'all.
All right, so it may be, Mr. Gunnell, that Ms. Wood tells you some things and then she'll ask you a question. Just make sure that you give her a thumbs up if you agree or thumbs down if you disagree, so she gets a sense. What's going on. Okay. All right. Let's see if we can make it work.
Let's do it.
Thank you, Judge.
Yep. I did not know that Mr. Walker wouldn't be brought over here. I'm not quite sure how the interpretation is going to work.
I was wondering that as well, Judge. I do know that, I mean, just based on my familiarity with the case, he has been able to read sign language when it's been remote, via Zoom or something like that before. And so we can try it that way and see if he's comfortable with that.
Okay. Ms. Nelson, do we have any interpreters?
They were supposed to sign on at 4. Let me reach out to Tanja.
Okay, they're not quite late yet. I just wasn't sure if they got on early. I'm gonna activate, what are we, 3 South Booth 1.
And I did bring that to her attention that he would be in a Zoom booth.
Okay. Hello, Deputy Gordon. All right. Mr. Walker, can you hear us at all? Okay, understood. I don't do sign language. I'm gonna do this.
Ms. Richardson said they should be logging in at 4, Judge.
Okay.
I think he's writing one himself, Judge.
Got it. And let me do this. Spotlight me.
May I step out briefly, Judge?
You may. Just gonna use that table.
I just thought rather than moving the screen back and forth.
No, it's all good. Wherever you want to be.
I can, wherever everyone else is most comfortable. So we have no plea from Mr. Johnson's client this morning.
No. Which is blowing up the trial calendar.
Sure.
Ms. Gordon, you are free to go if you want. Oh, no, wait, because we may have Ms. Woods in a breakout where there may be a plea. So everyone stick around.
That's fine, Judge.
Thanks.
Thank you.
Thanks. I know it's been a little bumpy.
Oh, it's okay.
All right. It is a little after 4. Do we have our interpreters?
Judge, good afternoon. Can you hear me?
Hold on one second. Yes, ma'am, I can hear you.
One of the interpreters for, I believe, Mr. Walker. I'm a sign language interpreter, and there's going to be another interpreter coming on who will be interpreting for him as well.
Do we need both? This will be a fairly short proceeding. So I have had trials before where we've had sign language interpreters, but because it's a 3, 4, 5 hour situation, obviously you need to take a break and have a replacement. Do we need 2 simultaneously? Because this is going to be about a 5-minute process.
Apparently you do. I'm not sure why. There is a CDI schedule. So she's deaf and she will be basically interpreting for him. I am not sure why, if he has used somebody like that in the past, and that's why they schedule her.
That seems like an awfully elaborate process. I don't want to ever interfere with the individual's ability to understand the proceedings, but it seemed like you and Mr. Walker might be able to communicate. We'll wait a little bit longer for this other individual, but then we may see how productive we can be relying solely on your services.
Okay. I'm texting her right now, and then she's gonna log in.
Okay.
And we'll see how it goes. And I can certainly try if it doesn't work out with Miss Amy.
Great.
Thank you. Just a few more minutes.
Okay.
Do you want me to ask Mr. Walker if he wants the CDI?
Please do. More so, even if your colleague is able to join us, it would be good to know.
He's asking, what does that mean?
That suggests a lot.
He's joining right now. Give me a second.
Okay.
I think she's joined. Her name is Amy Peterson.
Okay.
Okay. He is saying he wants the CDI.
Okay.
Okay, good. One moment.
Ms. Peterson is here. I've asked her to start her video.
Okay, I think she's trying.
Okay. Ms. Cox, help me understand what it is that Ms. Peterson will do that you don't do.
Well, I'm hearing, so I can hear and speak. She's deaf. So she will communicate with Mr. Walker in a better way. Not that I couldn't, but just for communication purposes. Sometimes depending on the person's level of signing skills that might need a CDI. It's just to make sure our communication is clear.
Okay.
Especially with legal assignments, we tend to do this.
Yep. Well, she dropped off the call again. We'll see if she's able to connect successfully. If not, today is a very low-key event, and so we will proceed with you.
Okay.
How was courtroom 2B today? Makes you miss it up here, huh?
She was on Zoom. She was.
Is Ms. Feely, Ms. Wood, which one of you is representing Mr. Walker?
Good afternoon, Your Honor. I have him, Ms. Primovic. Ms. Feely had to run to another appointment.
Got it.
I have him.
Great. Thanks for being here.
Yes, sir. Always a pleasure.
You need to say it like you mean it.
Always a pleasure, Judge.
There you go. That's much better. All right. Can you explain, Ms. Cox, that we are having trouble getting Ms. Peterson on this call? And we're going to try to go forward anyway, but if Mr. Walker gets uncomfortable with that, we'll stop.
I would rather have the CDI.
Okay. Then we'll have to bring him back to court on another day.
Give me 1 second.
Judge, can you give them, Tanya's reaching out to her. She thought she had logged back on. Just one moment, please.
Okay.
And Your Honor, just for your knowledge, Ms. Feely saw him yesterday and they passed notes back and forth through the attorney booth, and she did file a waiver of arraignment, just for your knowledge.
Okay. I didn't realize that. With the waiver already filed, we don't then need to wait on Ms. Peterson. I can just introduce myself to Mr. Walker.
Sounds good.
Thank you. So, Mr. Walker, I'm Judge McBurney.
Okay, go ahead.
Your lawyer, Ms. Feely, who you met yesterday?
Yes.
Will be out to see you again
Yes,
soon.
Ms. Peterson. I'm sorry. There she is. Okay. I'm sorry, Judge.
That's okay.
She's just introducing herself, saying this is Amy Peterson, it's the CDI, and I will be just using my voice and interpreting for her.
Now I see how the process works.
Okay.
Thank you. And good afternoon, Ms. Peterson.
Good afternoon.
How is Ms. Peterson able to understand what I'm saying?
I can see the interpreter, the hearing interpreter on my FaceTime we are both on a cell phone, so she can see me interpreting for her.
Got it. Okay. Thank you. Mr. Walker, your lawyer, Ms. Feely, will be out to see you soon. She will have papers with her about your case. She will talk with you about what's going to happen next in your case.
Okay.
I will see you again when there are any motions that I need to hear, arguments from the lawyers, or if you have resolved your case, or when it is ready for trial.
Okay.
Do you have any questions for me, Mr. Walker?
Amy's explaining, Mr. Walker thinks Ms. Cox, myself, is the judge, but Amy's telling him that it's not, that you're the judge. And there you go. Thank you, Judge.
So does he have any other questions?
No, seems like I don't.
Okay. Well, thank you, Mr. Walker, for being patient. Thank you, Ms. Peterson and Ms. Cox, for your services. Ms. Primovic, is there anything you want to add at this time?
No, Your Honor. Thank you, sir.
Mr. Shapiro, any concerns you've got about getting discovery to Ms. Feely?
No, Judge, we'll be able to get that to her by close of business today.
Fantastic. All right. I think that's it. Ms. Nelson, do we need to do anything else for Ms. Cox or Ms. Peterson?
Not that I'm aware of. I think Tanja will handle that.
Okay. Well, thank you so much for your services, both of you, Ms. Cox and Ms. Peterson.
Thank you so much, Judge.
All right, and please let Mr. Walker know he can leave the booth now.
Okay.
Great.
Thank you.
You bet. Thank you both.
Thank you. Bye-bye.
And thank you, Ms. Primovic, for letting us know that the waiver had been filed.
You're welcome, Judge. Took me a little slow on the uptake on that. Sorry about that.
You know what? It's first day back for a lot of people.
I haven't witnessed one of these either. That was good.
We had a whole trial. I think Ms. Korean represented the guy in here. It didn't. No, it wasn't. It was Alvis Moore. He fired Anna Korean and hired Alvis Moore and got life without parole. Very similar charges. Also deaf. But didn't have. This was fascinating. The two-level interpretation that had nothing to do with the outcome of the case, but we'll need to be sure we get this lined up the right way as it moves forward. I think that covers everything. I appreciate. Oh no, we've got Ms. Wood and a potential plea. I was about to say, everyone go home. Ms. Wood, how are we doing?
Ready, Judge. Sorry, we do have one plea left.
there is always time for another plea. So you're good to go. Thank you, Mr. Shapiro. I hope you will, because anything Mr. Johnson was going to try isn't going to be tried. So
unfortunately, that's my only one.
Oh, what was that?
Sam Greer.
Oh, okay.
It's position 18 or somewhere there.
Yeah, but it also means Jerry Peck doesn't go anywhere, and we're not going to be able to do Tolbert and Williams.
I can tell you with my position, Judge, if we are able to find a conflicts attorney to step in even temporarily for Mr. Johnson, it's not going to be a trial. It'll be a resolution.
Okay. All the more reason to reach out. And is that person in custody?
That person is in custody.
Because that escalates things over with GPDC. Okay.
Unfortunately, that person is in custody.
Okay. All right. Thank you so much. All right. So you want to bear with us. One last thing. Got that plea for booth 1. Oh, I know where he is. Hey, Mr. Gunnell, can you hear us?
Yes, sir.
Have I been pronouncing your name correctly? Is it Gunnell or Gunnell?
Gunnell.
Gunnell. All right, Mr. Gunnell. What Ms. Wood tells me is that you have worked out a plea. Is this going to be your case, Mr. Jordan? I hope so. You're the only prosecutor around.
Yes, sir.
Okay. For us to do that, we need to get you under oath. Mr. Jordan is going to put you under oath in just a moment. And let me add him because he will have an active speaking part. There we go. He's going to put you under oath. He's going to ask you a bunch of questions. You need to answer his questions truthfully and completely. I may have a few as well. Please be truthful and complete with those. If you have any questions, it is important that you say, hey, time out. I couldn't hear what you said, or that doesn't make sense, or that's different from what Ms. Wood promised me, and we'll work through that. Will you let us know?
Yes, sir, I will.
All right. When you're ready, Mr. Jordan.
I'm ready, Your Honor. Mr. Gunnell, it is?
Yes, sir.
Can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may place your hand down. Thank you. Can you please state your true, correct, and legal name?
It's Ricky Bernard Gunnell Jr.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir, I'm not.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 46 years old. I graduated Fraser Davis High School.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the following offenses? Count 1, being possession of firearm by a convicted felon. Count 2, being possession and use of drug-related objects. And count 3, being reckless conduct.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known
Yes, I
to
have. Yes, I have, sir.
Thank you. If you just allow me to finish the question, I appreciate your enthusiasm. Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir, I have.
Do you need any more time to discuss the case with your attorney?
Sorry, I do not.
Are you satisfied with her services?
Yes, sir, I really am.
Ms. Wood, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Gunnell's name?
So waived.
Mr. Gunnell, do you recall having been arrested on these charges?
Yes, sir. Yes, sir. I recall.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Wood, do you know of any outstanding warrants that are related to these charges?
We do not.
Mr. Gunnell, has your attorney advised you the minimum and maximum sentence for each charge that you're pleading to?
Yes, she did. Yes, she did.
Okay, and just for the record, Your Honor, for count 1, possession of firearm by a convicted felon, the minimum is 1 year and the maximum is 10 years. For count 2, possession and use of drug-related objects, that is a misdemeanor. So the minimum would be 1 day and the maximum would be 12 months. And as to reckless conduct, the minimum would also be 1 day and the maximum would be 12 months. Was that what was communicated to you, Mr. Gunnell?
Yes, sir.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as to count 1, the possession of firearm by a convicted felon, the state's recommendation is 5 to serve 6 months, commuted to time served, the balance being probated. And I apologize, Ms. Wood, what is the name of the program that Mr. Gunnell is currently or was in before being incarcerated?
It's Alliance Recovery Center.
Yes, Your Honor, and we wanted to make it a special condition of probation that he continue to participate in the Alliance Recovery Center. As to count 2, the state's recommendation is 12 months probation to run concurrent with count 1. And as to count 3, reckless conduct, the state's recommendation is 12 months probation to run concurrent with count 1. Do you understand that the court does not have to accept that recommendation, Mr. Gunnell?
Yes, sir, I do.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, sir, I do.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, sir, I do.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering guilty plea today?
Yes, sir, I do.
Do you understand that since you're being placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I do, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir, I do.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect the following: your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, and finally, the ability to obtain employment?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir, I do.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir, I do.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, And finally, the right to appeal if convicted of these charges after a trial.
Yes, I do understand that, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir, Mr. Jones, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Gunnell, how do you plead to the charges of possession of firearm by a convicted felon, possession and use of drug-related objects, and reckless conduct in indictment number 20 SC 177130?
Yes, sir.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that for the felony charge, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And for the misdemeanor charges, you have only 12 months from today to file that same petition?
Yes, sir.
And Ms. Wood, did you advise to Mr. Gunnell his deadline for withdrawing and for filing his direct appeal?
We did.
Your Honor, for a factual basis for this plea, on March 4th of 2020, officers from the Atlanta Police Department responded to a call at 407 Sunset Avenue in reference to a Black male wearing all black, waving a gun around in the air. Upon arrival, they met with the caller and the witness. The witness stated that the suspect was waving the gun in the air and had dropped the gun and was now passed out on the sidewalk. The witness pointed the suspect out and showed the officers where the firearm had been dropped. The suspect then was across the street at 407 Sunset Avenue and was passed out on the sidewalk, face down in the rain. The firearm was in the driveway of that same location. The suspect was then detained and was identified as the defendant, Mr. Ricky Gunnell. When standing up, the suspect had a hypodermic needle that was located under him. The suspect at that time did indicate that he was diabetic. EMS did report to make sure that he was not having any issues with his diabetes. It was shown that Mr. Gunnell is a convicted felon out of Fulton County for a conviction for theft by receiving a stolen automobile for January 14th of 1988. The officers then did state that they believed that Mr. Gunnell was high on heroin at the time of the incident. These events did take place in Fulton County, Georgia. Your Honor, that concludes the factual basis for this plea. Between the conversations that I've had with Ms. Wood, we do believe that this was not so much an incident that showed Mr. Gunnell as a dangerous individual, but that this was spurred on by drug use. Ms. Wood did inform me that he currently is with that same alliance program that has been of benefit to him. You may hear from probation or from pretrial that Mr. Gunnell has a long history, but we did believe that those convictions were older and that getting Mr. Gunnell help and continued help was the best negotiated resolution in this case, Your Honor.
Got it. And I have his repeat offender notice that shows many convictions, mostly drug or arguably drug related, a theft by receiving type conviction, but they're from the 1990s and the early 2000s with there was a 113 SC in there. But it all does look like it flows from addiction.
Yes,
okay,
Your Honor.
Got it. Thank you. So, Ms. Gordon, I do have in front of me a quasi-criminal history in the form of the District Attorney's Office's repeat offender notice. How many cycles do you have for Mr. Gunnell, and what is your total count of felony convictions?
Well, cycles are 51 cycles beginning in 1993. The most current conviction within a 10-year period will be the 2013 violation of Georgia Controlled Substance Act that was out of Fulton County. I am still counting all previous convictions outside the 10-year period, Your Honor.
That's okay. You don't need to count beyond that. I mean, the list I have is already extensive. And even if you were to add 2 or 3 more, it's not going to change the accuracy of Mr. Jordan's description. All right. Thank you for that. So the most recent is that 2013. There's nothing
that is correct
since then. Got it. Okay. And Ms. Tucson, do you have Mr. Gunnell on active probation anywhere?
No active probation.
Okay. Thank you. Ms. Wood?
Thank you, Judge. Mr. Gunnell is 46 years old. He is a lifelong resident of Atlanta. He lives here with his wife and his adult son. He's a Frederick Douglass High School graduate. He was working at Publix prior to this arrest. Judge, as Mr. Jordan already stated, this case does stem from a substance abuse battle that he has been struggling with for the past 20 years. Mr. Gunnell and his wife both tell me that he voluntarily entered into Alliance Recovery about 6 months ago, and it's been just absolutely life-changing for him and his family. This is an old case. It's almost 3 years old. So I think that is another thing that factored into part of our plea negotiations. He served 124 days on this between 2 different jailings. So he initially did 85 days and then he's done 39 days up until today. As you heard, no conviction since 2013. We would just ask that you accept the state's recommendation for Mr. Gunnell.
Mr. Gunnell, what can you tell me about the Alliance Recovery Center program? And in particular, I'm curious to know if it has a particular duration, how long you need to participate in it. Is it residential?
No, sir, it's not residential, but it has a big influence on my recovery because it gets straight to the point what I was doing with heroin, right? And it fit me exactly to the T, Honor, and it helped me so much. I love it.
Where is it?
It's on it's in Decatur, Ponte Leon.
How do you get there?
My wife take me there every morning. I catch the train every morning to go there. Yes.
It's a daily?
Yes, sir, it is.
5 days a week or 7?
5 days a week, sir. Six days a week, sir. Sorry.
Okay. And then you were also working at Publix?
Yes, sir. Yes, sir.
Any idea whether that job remains open for you?
If it's not, sir, I will be soon working somewhere, sir. So I got to have employment. I will have employment.
Does your wife work?
Oh, yes, sir.
What does she do?
She's a mail carrier.
Works for the Postal Service?
Sir.
Okay. And your home, is it in Fulton County or in DeKalb County?
It's in Fulton County.
This case happened a while ago. I guess you didn't know you had a warrant. How did you get picked up on the warrant?
I was just walking down the street and got pulled over, sir.
So you don't get pulled over while you're walking, meaning officers walked up to you, or you were in a car that got pulled over?
I was just walking.
Okay.
Walking. Yes, sir.
And these guys said, "Hey, show us some ID," and then ran your name.
Exactly.
Okay.
Yes.
Okay. Why do you think Alliance Recovery Center is making a difference?
It's tailor-made for me because they have everything I need to get ahead. I mean, I love it so much. I mean, I get along with people and they really are helping me.
Are you taking Suboxone or anything to help with the heroin?
I was taking methadone, yes, sir.
But you're done with that?
Yes, sir. And now this is the second part with the counseling, and I love it, Your Honor.
Okay. All right. And how many days did you say, Ms. Wood?
Ms. Wood, okay.
Different question. How many days did you say Mr. Gunnell has done when you add the numbers together?
Overall, Judge, it's 124 days.
Okay. All right. Mr. Gunnell, anything you want to add to the discussion we've had?
Nothing, sir. I'm just trying to keep going with rehabilitating myself, and hoping I can do that. Hopefully I can do that.
Okay. Ms. Gordon, we were focused on convictions, and you did mention the number of cycles. What are the two most recent cycles for Mr. Gunnell?
Ma'am, Your Honor. Sorry if I'm off camera. I'm just reading from the GCIC, Your Honor.
No problem. And I didn't need to know the substance of them so much as the date of the last two cycles.
The last two, the cycle 51 was April the 8th of 2021 as the last arrest, theft by shoplifting out of Hateville by the Hateville Police Department. That resulted in a reduced 2-day sentence in confinement, and that case number 21 CR 002298C. The one before that, the 50th cycle, one moment. That arrest date was February the 5th of 2021 out of DeKalb County. Was a violation of probation. Underlying charge was battery, criminal trespass.
Okay, thank you so much. All right, Mr. Gunnell, that just helps me get a little more current with what you've been working through. I do find there's a factual basis for your plea. Way back in March of 2020, you were clearly going through an episode with you passing out and the gun and the hypodermic, et cetera. I'm glad that it ended safely for you and the people around you. No doubt noticed in the media, some guy dressed all in black who pulls out a gun and waves it around is likely to get shot. And so hopefully you're going to steer clear of guns and drugs as best you can. But I don't need to tell you that. You know it better than I do. I do find there's a factual basis for your plea and that your plea is knowing and voluntary. Do you have any questions about any of the things Ms. Wood or Mr. Jordan or I have been saying to you?
No, sir. You just say the truth, sir.
I'm going to sentence you pursuant to the Probation Options Management Act. And all that means, Mr. Gunnell, is that while you're on probation, if you have a minor violation, I hope you have none, but if you have a minor violation, you and probation will work through that. It doesn't come to court. If it is a major violation, meaning you get arrested again, or you get kicked out of Alliance Recovery Center, something like that, that comes back to me and you and I will work through that. I'm going to sentence you on count 1 to 5 years to serve 4 months. You'll get credit for all the time that you have served. You've served more than 4 months, so you ought to get released over the next couple of days. The balance will be probated. Count 2 will be 4 months to serve. Count 3 will be 4 months to serve. Those will run concurrently with, at the same time with, your sentence in count 1. That means you'll be on probation for 4 years and 8 months.
Yes, sir.
The special condition of your probation will be that you continue to participate in the Alliance Recovery Center for at least 6 more months. You can do it for another 2 years if they'll do that with you, but you need to be in there for at least 6 more months. If it's 2 months from now and probation reaches out to Alliance and they say, Gunnell, we haven't seen that guy in weeks. That'll be the kind of violation that comes back to me. Okay?
Yes, sir.
I'll also waive your probation supervision fees for the first 2 months while you figure out what your next job is going to be, whether it's back at Publix or doing something else. You're not going to need to worry about paying that probation supervision fee those first 2 months, but then you are on the hook for it. I will also set a behavioral incentive date, new year, new practice. Let's do this, of January 31st of 2025. And what that means is that if in January of 2025, you've been doing fine on probation, probation will be free to close out your case.
Thank you, sir.
Mr. Jordan, anything else on behalf of Mr. Gunnell?
Nothing further from
I guess on behalf of the state, that's who you represent.
the state. Yes,
All
Your
right.
Honor, nothing further from the state.
Ms. Wood, anything else on behalf of your client?
No, Your Honor, thank you.
All right, Ms. Tucson, what do you need to get from Mr. Gunnell?
Is this going to be a facility, or he will just be going over to the facility the 6 days a week he mentioned?
He visits it. It is not residential, so he's going to be going back home with his wife.
Okay, Ms. Wood, do you have that information? Will you be residing in Fulton, Mr. Gunnell?
Yes, ma'am.
Do you know where probation is?
Yes, ma'am.
Okay, I'm gonna need you to report to probation at 276 Memorial Drive.
Yes, ma'am.
And when are you gonna be released from custody soon, or?
Yes, it's effectively time served. I gave him 4 months and he's done a few days more than 4 months.
Okay, so then, okay, we're gonna do January 17th.
So that's an important date for you, Mr. Gunnell. If you miss that, they're going to take out a warrant, and here we go all over again.
Okay, yes, sir. I'll be there.
And I will get your information from Ms. Wood, but just remember, January 17th at 8 a.m.
January 17th at 8 a.m. Okay.
And if you forget, you just need to reach out to Ms. Wood. She's writing it down. You can call her and say, wait, when was I supposed to be at probation? And she'll tell you.
Yes, sir.
All right. I think that completes everything. Ms. Livingston, you did a great job. We threw a lot of defendants at you, and then these inmates did some interesting things today. So thank you for managing all that. Ms. Gordon and Ms. Tucson, thank you. And oh, wait, one last thing. You don't have to remind me twice. Mr. Gunnell, do you authorize my staff to sign the indictment for you indicating your guilty plea?
Yes, I do, sir.
Ms. Wood?
Yes, Judge.
Mr. Jordan?
Yes, Judge.
Great. We'll take care of that, and that'll get your guilty plea taken care of. Just let me finish thanking everyone. It's a long afternoon, but we did it. 2 pleas. Fantastic. Great way to start the year. And I'll see everyone's smiling face in person or virtually as we call our trial calendar tomorrow.
Judge,
Looking forward to it.
everyone needs to attend in person.
I will see everyone's smiling face in person tomorrow as we call the trial calendar. Okay?
All right. Have a good day.
Thank you. Bye-bye.
Bye now.